All right, I think we'll go ahead and get started. Welcome, everyone. Thanks for joining us this morning. My name is Barbara Colombo, and I'm a professor and the director of the Health Law Institute here at Mitchell Hamline. We have over 100 participants joining us today, which is great. Today's event, which is co-sponsored by Gardner Law, is entitled AI in Healthcare, Adapting to World-Changing Technology. Just for your records, this event has been approved for 2.75 CLE credits. We have a group of phenomenal speakers that will share their expertise with you through 4 different presentations. Following the presentations, we will be having a panel discussion. If you are interested in asking any questions at all, please feel free to put those in the chat and we will get to them during the panel. If you could also indicate to whom you would like the question directed, that would be really helpful for us. As part of the Health Law Institute's commitment to making students practice ready, upon graduation, we work with our students to hone practical skills, including the ability to communicate effectively. I am very excited to introduce our student moderator for today's event. Molly VandeVoort is a student here at Mitchell Hamline. Molly has her MPH and is also pursuing her law degree and certificates in health law and healthcare compliance. Molly is a healthcare policy expert with extensive experience at the Centers for Medicare and Medicaid Services and in the private sector. She has led a number of initiatives on Medicaid drug programs, the No Surprises Act, and medical policies in managed care. Molly is currently a senior principal at Coforma, where she translates complex healthcare regulations into actionable business strategies. So with that, I'll turn it over to Molly.
Thanks, Professor Colombo. So first today, our first speaker will kick us off with an overview of AI, and that'll be with Mark Gardner. Mark is a founder of Gardner Law, and he specializes in FDA regulatory, compliance, and privacy law. With over 2 decades of experience, Mark helps healthcare companies manage legal risks, conduct due diligence, and ensure compliance with myriad regulations. Thanks for kicking us off, Mark.
Thank you. Appreciate that. I do not see the slides. That might be my issue here. Are the slides up?
We do not see the slides yet, Mark.
Okay. All right, see them now?
Yes.
Good.
Great, thank you. So thanks, Molly, for the introduction. So I'm going to just start off with giving us a little background on AI. It's a ubiquitous term now in our society. It's hard to, read a news article without hearing about it or watch a news report. So just to ground us, I think we probably all know what AI is. I know I was using it this morning to fill out my NCAA bracket, trying to use ChatGPT to help me figure out the potential upsets, but it's used in healthcare, and that's really what we're focusing on here today. So I won't read much in this presentation, but I will in this case, and I'm going to present for about 20 minutes and hand it over. But artificial intelligence, what is that? It's broadly defined as the science and engineering of making intelligent machines, notably intelligent computer programs. AI can use techniques such as models based on statistical analysis of data, expert systems that primarily rely on if-then statements and machine learning. So if you remember back to your statistics, if any of you had statistics, your if-then type of computations, decision trees are the basis of AI. Machine learning is an AI technique, so now we're going like a layer down. It can be used to design and train software algorithms to learn from and act upon data. Software developers can use machine learning, and I'll call that ML. If you hear me say that, it's machine learning, to create an algorithm that is locked so that its function does not change or adaptive so that its behavior can change over time based on new data. So if you're using ChatGPT like I was this morning, that's an adaptive model that's incorporating new data, for example, on different basketball teams to hopefully help me prevail over my competitors in the tournament. And I think the tournament starts at 11 a.m. this morning, so hopefully you got your bracket in. Why is this important in healthcare? Where it's really especially important, it's not, AI is not at this point replacing practitioners. For the most part, I'll talk about some examples where it's definitely made some major inroads. But it is used in healthcare when there's an enormous amounts of data that are generated during the delivery of healthcare. So humans are not as good at keeping track of 1,000 data points compared to a machine like AI and machine learning. It can learn from real world use and experience that can improve its own performance. So in that sense, obviously, if you've been an attorney for 1 year versus 30 years, you're improving hopefully every year. AI kind of take that same concept, apply it to AI. It's actually improving as it goes along. Manufacturers are using AI and machine learning to innovate their products and to assist the providers in improving patient care. Some examples of how it's being used to assist providers and improve patient care. I'll just kind of jump around on this list a little bit, but assisting in diagnosing is a major one. If you remember Watson from IBM, that was something that was kind of we heard a lot about in the past. That was used, talked about, say, 10, 15 years ago about how that will assist doctors with diagnosing. Well, that's real today, and we don't need a supercomputer like Watson necessarily to do it. It's in the palm of your hand. I suspect many of you have gone on and maybe used AI even to try and see what your child has or what you may have. If you have certain symptoms, you may say, do I have the flu? I'm feeling these symptoms. Most of the tools will tell you, this is not an opinion when it comes to your healthcare. You should go and talk to your doctor, but it is actually quite useful. I know I've used it for doing that, and it can help you diagnose yourself. Doctors will call that Dr. Google, and obviously you should go and see a doctor if you have a problem. It can also help predict post-surgical outcomes. So if you've had a medical device implanted in you, and maybe it will help the doctor determine what the longevity of that device will be, or how it will help you, or when it will fail, perhaps. Remote surgery as well. There's a lot of applications used in surgery where it can help pinpoint where the place to cut, so to speak, is. And there's new applications constantly evolving. These are different segments where AI and machine learning are used. It's mostly radiology, and radiology is using a lot of technology to help diagnose and treat patients. Cardiovascular, so there's a lot of devices, for example, pacemakers and devices like that are so-called smart devices that are implanted in a patient and are constantly delivering information into the cloud, some center, perhaps at the company, perhaps at the provider's office, or both. And those data are then used to analyze what the body is doing. There's a mix up in this 1% is really evolving, and I suspect this list will look a lot different in 5-10 years. But right now, radiology is a major area. So like reading diagnostic scans, for example, which I have a picture here of the brain. If you're trying to detect a embolism in the brain, AI is a great place for that. But other areas, neurology, hematology, GI, urology, ophthalmic, clinical chemistry, ENT, dermatology, and more. All of these areas have a common denominator, which is generally looking at a lot of data and trying to find patterns in those data or to identify an anomaly. So I provide an example here of AI and machine learning where it's trying to detect an anomaly. And just to kind of make this story short. And this was taken from a New York Times article on AI and how the FDA regulates AI and some of the great things about it and some of the concerns. There's a physician featured here, and I'll just read this quote because it kind of cuts to the matter. He was actually seeing a patient, and it was a remote visit, and he started to feel like he was having a stroke. The doctor did while he was seeing his patient. And so he went to the doctor himself, and here's where it picks up. The image that was taken of his brain went to Greensboro Radiology, a radiology partners practice, and Radiology Partners is a massive user of AI, where it set off an alert in a stroke triage AI program. A radiologist didn't have to sift through cases ahead of Dr. Fagan's or click through more than 1,000 image slices. The one spotting the brain clot popped up immediately. So this doctor felt like he's having a stroke, went to the doctor. AI was used to analyze the 1,000 images of his brain, and it found the clot immediately. And the story goes on, and you can search this article on Google and read it. But it goes on to say that he was feeling better and wanted to return to work on Monday, and he took a week off before he went back to work. But if you're having a stroke and you don't have the clot detected quickly, you can die, and it's a matter of hours. And so, having a human try and look through 1,000 pictures versus having the AI, the computer, so to speak, find the clot in seconds, obviously that's a much better outcome. The article talks a little bit about how not all AI systems are created equally, and the individual that is at Radiology Partners leading that practice, which have thousands of radiologists, she worked really hard to find the best technology she could, and she's using it, and it's really helping radiologists detect clots and do their jobs better. And there's many other applications, as you can imagine, for AI when you're trying to detect a large amount of kind of trying to sift through a lot of data and find an answer. Here's the other side of the argument. It's not perfect, that's for sure. And in this case, again, I'll just read here. This was a tool that was used in a system. And these are cleared devices, by the way. And the University of Michigan researchers examined a widely used AI tool in an electronic health record system meant to predict which patients would develop sepsis. And as you all know, sepsis is very bad. If you have sepsis, you can die of toxic shock. They found that the program fired off alerts on 1 in 5 patients. So it was saying 1 in 5 were positive, though only 12% went on to develop sepsis. So those are what we call false positives. And you can imagine that's very disruptive to the provider's work. If AI is telling them this patient's going to get sepsis, then they go down a completely different path in terms of treatment. And if only 12% of them really have sepsis, that's very wasteful, and it could hurt that patient if they're being treated for sepsis when they should be obviously treated for something else that could hurt the patient. So it's not perfect. And the FDA is doing its best to make sure that the American public is safe safe from devices that don't work and that the devices are effective. And so this is a very cutting edge area that the agency is trying to get right. And I think they're doing a pretty good job. We at our firm have a lot of respect for the agency. And it's an agency of scientists, and they are data driven. And so as this evolves, we'll see some more changes potentially even to the law in the future, and I'll talk about those in a minute. But just to give you a little background, the first device was cleared in 1995 that contained a rudimentary AI, if you will. It's not like what we have today. Since then, there's been over 1,000 devices cleared through the third quarter of 2024. I would suspect, we have a parabolic growth trend here taking place with the devices. So I suspect there's many more that have been cleared since, and those data are updated by the agency about every quarter or so. So you can go on and check that as well. You can just Google AI devices cleared, approved FDA, and you can see every device that's been cleared through the end of September of last year. How are the devices cleared by the FDA? Mainly three major pathways. I guess we could say um, four if you were to talk about some wave devices, which I'll talk about in a minute here. But that's really not a pre-market review. But they're cleared. The ways that they are approved ahead of time by the FDA, they're reviewed and approved ahead of time. It's either 510(k) path, de novo path, or PMA pathway. And this is something I walk through with students I teach at Mitchell Hamline and educate them on these topics, or teaching the class right now, in fact. So my students could hopefully recite all of these pathways for you. But in summary, 510(k), I'm going to give a very high level way of thinking about this. If there's already some other AI product out there with the same intended use and same technological characteristics, then a sponsor can say, hey, my device is like that device that exists, and I'd like to have clearance, and the sponsor makes certain promises to the agency that they're doing certain things. And if the FDA agrees that device that the sponsors come up with is as safe and effective as the predicate device, then it will be cleared. There's also a de novo pathway, which I'll talk about in just a moment. But the type of devices for a 510(k) that are right for that would be things like imaging navigation systems, ablation systems, balloon dilation devices. These are medium risk, if you will. Higher risk devices go under the PMA pathway. These are going to be things like pacemakers, neuromodulation, drug delivery devices that are implanted in the body. And the sponsor in those cases has to prove outright that the device is safe and effective. And there is no predicate. There's nothing like it on the market yet. These are your high risk devices. If something is not considered high risk, but there's no predicate, there's nothing like it on the market, then the sponsor can go for what's called a de novo pathway. And it's sort of in between 510(k) and PMA, but you do generally need to provide clinical data to support the safety and effectiveness of the device. So if what I just told you is kind of confusing, that's okay. The summary is that there's different levels of how devices get on the market, and it's driven by the safety profile of the device. The riskier it is, the more data FDA is going to demand, which makes sense. There's also in-house systems which generally do not require pre-market approval or clearance. And those can be developed by the providers like Mayo, Stanford, Duke. They all have their own AI systems. And they just need to be used basically within the hospital systems. They can't be then branded and sold to other providers outside of the institution. If they do that, then they will be subject to these pre-market pathways that we talked about, 510(k) PMA. So FDA is looking at some of these in-house systems, though, because they're concerned like, that what if they're not made properly and we never reviewed them? And Mayo isn't just one clinic; it has a lot of clinics, and same with many big providers and big systems in the country. So more to come on that. Here's another example of a device that was cleared last year, and this is for detecting melanoma, for example. And it may be for just abnormal moles, not specifically melanoma. But you can imagine if you have like a picture of your skin, like I'm very fair skin and have had some issues with moles and whatnot. And so I could go in and have a picture of my entire body taken, and this device does that. And then if you go back in, 6 months later, we'll see if any of the moles changed. And this technology, according to my dermatologist, is not 100% there yet, but it's a step in the right direction. So again, that's another example of an area where if you were to take a picture of, I would suspect a lot of people attending the program here have some moles, which are normal, but it's hard for the doctor who looked at your mole 6 months ago to know if it changed or not. And so having technology and AI specifically using that can help detect those changes. Talking a little bit more about the law here, and I'm coming into the final kind of segment of this presentation, again, just to ground you all on AI and how the technology is regulated. The Congress has been thinking about this. They didn't create the 21st Century Cures Act in 2016 to address AI, but CDS, Clinical Decision Support Software, is sort of a it's precursor to the adaptive type of AI that we have today. As I mentioned earlier, we have AI devices going back to 1995, but Congress saw some of this coming. So they narrowed the scope of this specifically was talking about software. They wanted to encourage the inventors out there to continue to develop software, and they wanted to exclude some of it from being overregulated, if you will. And this is really Congress driving this. So I'll just read here this section 520 of the Food, Drug, and Cosmetic Act. They amended it to exclude certain medical software functions, including certain clinical decision support software, from the definition of a medical device. So that clinical decision support, I'll call that CDS. We live in a world of acronyms and FDA regulatory law. So that pursuant to this amendment, Congress said if the CDS software, it's excluded, it's not a medical device, which means it's going to be easier to get on the market or to use if you're a Mayo or whomever, if it meets these certain requirements. And if you step back, why did Congress do this? Again, they're trying to encourage advancement in the space so that we all, as patients, are treated with technologies that can help us and make providers' jobs easier and more effective. So it would not be regulated as a medical device. You would not have to go through the 510(k) program. You would not have to go through PMA or de novo. You could just start creating this device and selling it if it is not intended to acquire, process, or analyze a medical image or a signal from an in vitro diagnostic device or a pattern or signal from a signal acquisition system. So it's not acquiring this information, at least the signal part. 2, it is intended to display or print medical information about a patient or other medical information like clinical practice guidelines. So if you think about like an app, it's just, and maybe I'll just use that as an example. Like, so if the doctor has something on their iPhone, first of all, it wouldn't be hooked up to an MRI. It's not acquiring that data from the MRI to process it and analyze it. It could hook up to the MRI just to display the picture. And then 3, and we'd still be in bounds. It is intended to support or provide recommendations to an HCP an HCP is healthcare provider, about prevention, diagnosis, or treatment of a disease and condition. So it's just supporting the provision of a recommendation. But 4, it is intended to enable the HCPs to independently review. So the doctor's making a decision to review the basis for the software's recommendations. So HCPs do not primarily rely on the recommendations when making a diagnosis or treatment decision. So the summary here, the takeaway of this is really that the CDS is helping, but it's not making a decision for the doctor or making hey, do this. They have sepsis, treat them this way. If they go into that mode and say this patient has sepsis, treat them a certain way, it's a medical device. But if they're just repeating clinical guidelines, it's not. FDA went a little deeper, and if you're interested in this topic, you can read guidance on how FDA went on to interpret the Congress's intent. There's a lot of other guidances out there on how FDA is regulating AI and machine learning, ML. SMAD, there's a guidance on that. Software as a medical device. Predetermined change control plans, there's guidance on that, which is a hot topic. Each one of these could be a presentation in itself. But essentially what the FDA with its PCCPs is saying is if you have AI and it's going to evolve, we need to know how it's going to evolve and approve your plan ahead of time. Our job is to keep the American public safe. and make sure the devices out there are effective. So they would need some comfort around how that adaptive AI is going to work. There's also guidance on good machine learning practice and also real world evidence, among others. I won't get into this, but there's also the Federal Trade Commission out there that regulates AI. And they are, some of their key functions, regardless of whether it's AI or something else, they are going to prevent deceptive trade practices, unfair competition, and they want to protect consumers. So you'll hear discussion around AI acting in discriminatory fashion, because it's being driven by pools of data. And if you have disparate treatment among different patient populations, and that AI is then going to tell you how to treat people, it could be problematic. So if you have a AI system built on data that's from a Medicaid population and say the poorest county in the country, and it's going to take all those data and say this is how we treat everyone. It's probably going to look different than how if you were to pull data from how all the presidents of the United States going back, or a Congress, whatever kind of elite group you want to think about, they're likely going to be treated differently. There's maybe more tests run on those folks. Maybe they don't care about the cost of care. And so we have to be careful to not have systems that will discriminate. And that's a pretty hot topic. FTC is on top of this. And so more to come on that. Really, we've had it with the change in administrations. We have changes at FDA that I'm sure you've all heard about. And, we have former Commissioner Dr. Califf was talking about AI, saying, hey, it's very exciting. It's a great chance for good, also a real chance to harm people. Marty McCreary is expected to be our next FDA commissioner, but he hasn't been confirmed by the Senate yet. And so we're in a bit of a shift. So we'll see what comes next in terms of FDA leadership on AI. Where are we heading? I would say generally, you're seeing the U.S. take an approach where, and you heard this from the Biden administration, you hear from the Trump administration, that the United States needs to be the leader in AI. And I think, if you were to ask domain experts in the area, they'd probably say that was true until recently. The DeepSeek really kind of shook up the sector, and the Chinese are they in the lead? We don't know. But you'll hear this from like trade groups like AdvaMed. They're saying, hey, we have what we need. We don't need to change the law and make it harder for industry to use AI and to develop new products with it. And so you'll see this fight kind of unfold here in the coming months and years. It's already happening in real time. You have states like Colorado and Virginia that are passing their own AI laws. And hopefully we don't have 50 AI laws in the country, and we ultimately have some federal oversight with one law. And Paul Rothermel, my colleague, talked about that more on how we have a quilt work we have many different laws in the U.S. for privacy, and that's creating challenges for industry because you have to deal with 25, 30 laws instead of one federal law. And this is one of the last comments I'll make here. New rules for AI in healthcare. This is still evolving as well. What's the standard of care, et cetera. But this group came out and said that doctors basically need to provide a rationale whether they followed the AI's recommendation or ignored it. So that will be interesting to see how that unfolds. That is it for me. I will hand it over to my next presenter. If anyone has questions, they can ask them, but I suspect you're going to have more questions later here in the presentation.
Great. Thank you. That was a really informative overview and very helpful as we dive in further into AI with healthcare regulatory considerations presented by Nate Downing. Nate is a managing attorney at Gardner Law, where he advises FDA-regulated clients on compliance, advertising and promotion, and a variety of regulatory matters. With expertise in pharmaceuticals, medical devices, medical foods, and nutritional supplements, Nate helps companies navigate complex FDA requirements. Over to you, Nate.
Thank you, Molly. Thank you, Mark. I'm going to get my slides up. So Mark really gave a good foundation for what I'm going to give a little bit deeper dive on. And so, what I would like for you to take away is, law students in the crowd, whomever you might be, what is the framework to get these AI products on market? Things that mitigate, diagnose, cure, treat diseases, right? Those are what FDA regulates from a medical device standpoint. But I want to set the stage a little bit too. You have to think of a couple things first. One is there's a lot of good science out in the world. There's a lot of science taking advantage of AI, of machine learning. That's very complex. And FDA has a lot of expertise in-house, but they cannot have expertise in every area that we're going to encounter, right? So at times, you have to remember that we're interpreters. We've got to take the science from our clients, or if you're in-house from your company, you've got to put it into a package that FDA understands. And the second thing to remember is AI changes rapidly, right? The amount of new uses and potential use cases for AI is evolving. And as that evolves, you can imagine, as Mark alluded to too, the regulatory framework is not evolving nearly as quickly. And so it is much slower. You can imagine that we all know how long it takes for laws to get passed. Rulemaking can be quicker, but it still can take a while. And some guidance documents take years to become finalized. So you have to be able to interpret the science as well as fit it into an existing framework that's really never going to catch up with AI. And so I think part of what industry's pushback, even, and you saw on the slide from Mark, of trying to get too strict and regulate and legislate AI is you're always going to be behind because AI is always a few steps ahead just based on how the science works. And so when you think about those problems and the roles you play, and now you've got to understand how you're going to get from a concept of maybe a life-changing, a life-altering treatment, incorporating AI and get it onto the market and get it through the FDA and be able to tell a story that everyone understands and be able to prove safety and effectiveness. So the way that I'm going to get us there, in my half hour is we're going to talk about the FDA regulation of AI, which Mark touched on, but we're going to kind of get a little bit deeper and then talk about some of the challenges you might face and then talk about how do you mitigate those challenges. A lot of it comes to being able to partner with FDI. And so one good thing is you can see the FDA approval of AI devices over time is just increasing. And so the familiarity at FDA is also increasing. And so even though you might have a novel treatment, there's a lot of issues that FDA has already encountered, which is always important because their guidance is going to be based on experience instead of trying to guess at the path ahead. And so it's also just interesting to think about that number constantly increasing. That also means your competition, your competitors are also going to have ideas. And so making sure that, your ideas stay fresh on the marketplace. So once again, wearing FDA shoes. If you're ever going to work with FDA, you've got to be able to communicate in a way that you are partnering, right? There's a little bit of an adversarial relationship, but there's also a lot of partnership that has to take place because everyone has the same goal. They want to get products that can help public health onto the market. And so once again, AI is exploding and the FDA is following a regulatory structure that was not made for AI. It can accommodate AI, but it wasn't made for AI. And so that means there's interpretation that has to occur on guidance, on regulations, on standards, on how do you prove safe and effective for a product that's constantly changing based on data input versus how did you prove safe and effective on a device 10 years ago that always gave the same output and it was always preset by a physician. There was no changing. And then FDA is trying to keep up with this innovation while understanding their main charge of protecting public health. So Mark touched on this, but it's always a good reminder, AI, and this is from an FDA website, is broadly defined science and engineering of making these intelligent machines intelligent computer programs. They use techniques such as models based on statistical analysis of data, right? That's really important to understand that if you're going to be capturing data and using it to guide how your device is going to treat, well, not only does FDA want to understand the statistical analysis that goes into that, but where are those data being gathered? Are they being gathered from a source that allows for accurate interpretation of the model? Are they being gathered from a wide enough base that now the patient population you're going to treat is covered? So you can already see that's not just a, do you have a device that does what you say? It's, do you have a device that does what you say while also properly incorporating whatever the algorithm being used for the machine learning for the AI is? And then the machine learning is an AI technique that's used to design and train software algorithms to learn from and act upon those data. And so, why is this important in healthcare? Well, we can imagine we're always seeking better treatment for patients, right? Everyone who's in this space, no matter what our role is, there's really one common denominator, and that's, can we get better treatment to patients, safe treatments to patients, in an efficient manner, all of the things that go into a healthcare system. And so AI and ML are used to derive new insights from the enormous amount of data that's generated. You can imagine every patient, every visit, every procedure, every study, all the amount of data that are gathered. And those data tell lots of stories, but it's hard to always parse out the stories and gather what's relevant and what might be important from each data set because of just the amount. And so AI and ML can be used to help crawl through those data, find what is important, what's going to help this certain patient in their treatment journey, and that can create more effective and efficient healthcare. Also, AI/ML, they learn from real world use and experience and can improve its own performance. In the last few years, FDA has issued guidance documents on the real world evidence. And so it's one thing to do a clinical study, right? And oftentimes what you'll see is a company will launch a clinical study and the numbers will look great, right? They're going to have a primary endpoint typically that they're going to need to meet to be able to get market authorization. And that endpoint, that those numbers might look great, but typically that might be the ceiling at times of the treatment because it's with physicians who intimately know the product, who have been trained as part of a protocol, who have a very specific protocol to follow. And then you launch a product into the real world, it might not be the same, right? And so AI/ML can look at these real world data and say, hey, we're not performing the same. What might be the difference? What's the delta from the clinical study to its real world use? And how can we help industry get patients up to the efficacy that we saw in these clinical studies? And so being able to utilize AI and ML and parse through those data, all the real world data that can be generated, and then improving its own performance, you can see how enticing that is, both from an industry perspective, from a regulatory perspective, and ultimately physicians and patients. Manufacturers are using AI/ML to innovate their products to assist healthcare providers and improve patient care. And once again, all of those data tell so many stories. And if you can find the right combination and the right algorithm, you can really have an effective product. So I think this is, we're talking about it. This is not the first conference I've been to speak on it. I've spoken on it multiple times, and it's because AI is perhaps the most transformational technology of our time, and healthcare is perhaps its most pressing application. So how is AI and ML in healthcare used? Well, you can predict post-surgical outcomes. A lot of surgery carry risk, right? And so not every surgery has the outcome desired. And so being able to better predict what the outcomes might be, allow patients and physicians to make better decisions on whether they should undergo a certain surgery or what might it look like from a perspective of post-operative healing, remote surgery, being able to learn, being able to treat more patients further away, right? And assisting in diagnosing. Diagnoses take time. I work with some companies who treat rare diseases, and a patient's journey to get diagnosed can be 2, 3, 4, sometimes 5 years. And that's not the physician's, malpractice. That's them following the mantra of when you hear hoofbeats, you look for horses, right? So they're trying to go through their list with the best technology they have. But if AI and ML can take a holistic view of a patient and assist in diagnosing and get to an earlier diagnosis, you can imagine the treatment can begin sooner, ultimately leading to potential better outcomes for that patient. Once again, help manage the amount of overwhelming data there are. And that's always going to be a big help for science, right? Science loves data, the FDA loves data, but how do you manage those data? And then additional applications are constant in this space. There's always new ideas. There's some startup forming today probably that has an excellent idea and a very worthwhile application. And those are a constant in this space. So Mark touched on this too, but I'm going to go a little bit deeper. The FDA regulation of medical devices. So the evolving nature of medical devices that utilize AI and ML differentiate them really in a meaningful way from traditional medical devices. A single model or version of device is typically improved upon and released as a new model or version, right? So we'll use a PMA device, you've got your approval. It's approved for a very specific indication, a very specific range in which the treatment can be delivered if it's something that provides a treatment. And that is what the physician can use until industry goes back and submits a new application for either a new PMA or a supplement, right? That's how change works for a device standpoint. So traditionally, FDA reviews these devices through whether it's a 510(k), de novo, or pre-market pathway. So a little bit deeper into a 510(k). So if your device has a legally marketed predicate device that is not exempt from pre-market notification, each submitter must receive an order that says that your device is substantially equivalent, and now it can be marketed. Substantial equivalence is very technical, and it's a review that the industry puts together, a package that says, hey, FDA, here's why we're substantially equivalent to this predicate device. And you've got to talk about technology, patient, population, mechanism of action, safety, risk classifications, all of those things go into determination of substantial equivalence. And so what you have is different classifications that talk about whether you can be in a 510(k), whether you could be a de novo or ultimately a PMA. And so I have a list of those classifications here. And it really is, are you low, are you a moderate, or do you sustain human life or of substantial importance in preventing the impairment of human health or present a really unreasonable risk of illness or injury? Oftentimes that's found in like a long-term implant, something that's in the patient for years, making sure that there's no chemicals within the implant that could harm, and other considerations. And so in a 510(k) sense, you're doing a pre-market submission made to demonstrate that it's safe, as safe and effective to a legally marketed device. And so you have to do a comparison of your marketed device to a device already on the market. And when you're talking about artificial intelligence, you can see how that can become difficult because of the purpose of AI, of ML, right? Is it's unique? Is it's different from something on market? And so having a good argument, having a good basis for your substantial equivalence discussion with FDA allows you to get to market faster, right? Because a 510(k) is from a FDA review standpoint is your fastest path to market. And so what are some devices incorporating AI that have required a 510(k)? So step back. Remember at the very beginning, we talked about, what my role is, what your future role might be if you're going to get into the similar type of work is an interpreter to FDA from this industry to FDA. But you also have to work backwards too. You also have to be able to guide your company. And you have to understand, is it a 510(k)? Might it be a de novo? Might it be a PMA? There's millions of dollars in spend and could potentially be years of different timing to market based on that answer. And so one thing you want to do is you want to look at other device types. What has FDA cleared? What has they given market authorization via de novo for? And what has ultimately required a PMA? Because that's going to guide your own assessment of your client's device. And so spinal implants have been used for some time to help with various spinal defects. They can be a 510(k) if they fit within a specific product code. And the AI is there to help guide the size potentially of the implant? What might their projection be? How are they going to heal post-surgery? What might be their range of motion after an implant? And so a lot of these implants that require the customization utilize AI. Recently, AI is utilized to predict the outcomes based on dimensions and location of implants. So you can see how spinal implants are even evolving within their clearance of a 510(k) to allow for more as long as they can continue to argue substantial equivalence to a predicate device. So then there's a de novo. This is really a device that does not fit in the 510(k) pathway because you can't find a predicate. That's the easiest way to say it. And so they're typically class 1 or 2, and they're going to be used for future predicates, but at the time, you don't have that predicate device. And so you're trying to provide a reasonable assurance of safety and effectiveness for that intended use. And then you have to also understand that you might need clinical evidence. So in a 510(k), I think it's like, a small percentage require clinical evidence. The vast majority don't. And that saves companies a lot of time and money. When you get to a de novo classification, while the review period is only about 60 days longer, you might now, or you're more likely to require clinical evidence. And that's very important both for your company, your client to understand, and also what FDA is looking at now is a clinical study that's going to provide data to give assurance, reasonable assurance of the safety and effectiveness of your device. And so you can see now the standard has gone up a little bit. If you're a 510(k), your pathway to market is simpler, if you will, as long as you can prove substantial equivalence. If you're de novo, it's a little bit more complex. And here are some devices that incorporate AI that have required a de novo in the past. And so a device that detects lesions within the GI tract. It relies on an advanced software algorithm. There was no predicate. This algorithm alerts when an image contains a potential lesion. So you can see the risk classification too is high because if there's an error, you could have missed a lesion that could have been cancerous or whatever else they're looking for. Due to this mechanism, it's an advanced software algorithm incorporating AI, a predicate was not available. And so you have to look not just on the device and what you're treating, but also the mode in which your device treats. And that algorithm was such a major component of this device that you could not find a predicate, so they had to take a de novo path. And then pre-market approval. This is the process of a scientific and regulatory review to evaluate the safety and effectiveness of a Class 3 medical device. Class 3 devices, as I discussed above, support sustained human life. It's just that their risk classification is high. Failure could lead to loss of life, serious injury, etc. And so a PMA approval, now you get approval here, right? A 510(k), you get clearance. De novo, you get market authorization. PMA, you get an actual approval based on a determination by the FDA that you contain enough valid evidence to assure the device is safe and effective for its intended use. So what does it look like for a device incorporating AI that required a PMA? A breast imaging system that results in a breast cancer diagnosis, right? So cancer is life-threatening. This is if this device misses the diagnosis, it could have disastrous impacts on that patient. So FDA wants a PMA so they can have the level of evidence required to say it's safe and effective. It also allows to differentiate between benign and malignant masses using AI. So you can see that the AI component there is very strongly tied to the safety and effectiveness of the device. It has a similar use of other AI products that were able to be cleared as a 510(k), but intended use plays a large role in classification. What that means is when FDA is looking at risk of a device, if you have a device that is what's called adjunctive, or it's going to supplement existing standard of care, your risk might be lower because they're already doing what they should expect to do from a physician standpoint, and now it's almost like a secondary check. If you are trying to be more of a primary means of diagnosis, then your risk classification goes up because the results of a misdiagnosis could be more disastrous because you don't have a secondary check or you're not adjunctive to the current standard of care. So FDA looks very closely at your intended use and whether it's going to be adjunctive to a standard of care or whether it's going to be a fully new treatment, and that helps FDA understand your risk profile and ultimately guide the type of submission you could require. So think about the traditional review of device modifications, right? So you get approved, and then FDA reviews and clears modifications to medical devices, including software, depending on the significance or risk posed to the patients presented by the modification. When applicable, the change in a medical device would trigger the requirement that a manufacturer submit a new pre-market notification to the FDA. So in a 510(k) sense, there's a very good change assessment document that FDA has that says, okay, if your changes fall within these categories, you can do what's called the letter to file, just document the change as part of your change control process and move forward. If it's a serious enough change, you have to do a full new 510(k), which, as you can imagine, that's a lot of work and a lot of money. Under the traditional FDA regulatory framework, changes to software require these new risk assessments to determine whether the change affects the functionality or risk category before releasing each change. That is, the algorithm is essentially locked, right? So we're talking in a machine learning and an AI sense. You're going to lock that algorithm out for future advancement until you've had these regulatory submissions. And you can see that that might defeat the optimization of the AI ML technology. You're looking at a technology that can fastly learn, fastly change, and essentially improve, but it has to have time constraints. And so you can always say you're behind a little bit on your treatment if you have to follow the traditional pathway. And so what are some market pathway challenges? Well, device classification. It's very difficult sometimes to put the AI, the ML capabilities into like a nice box and say, okay, well, here's the risks if it doesn't work. Here are the safeguards that we can have in place, the special controls potentially for a class 2 that allow us to launch this product but have continued post-market surveillance. The intended use, right? The intended use of an AI ML device could change based on the data, and it could potentially help patients, but FDA only allows you to market your device for your approved or cleared intended use. And so you have to be flexible in considering what your intended use is. And sometimes I'll tell clients, take a phased approach, go to FDA with your initial, but make sure you understand that you've got some fast follow submissions that might come. Or as we'll see later, and Mark alluded to, there's some change control plan documents we can take advantage of. And then predicate devices. This is always a very big challenge, and this is whether you are an AI/ML device or not. Do you have an actual predicate that FDA will say provides a basis for substantial equivalence? Or is your technology, your algorithm so unique, so novel that you can't take advantage of the 510(k) pathway, which once again triggers potential requirements for clinical study and then a little bit longer review period? So changes. Well, FDA has already approved, authorized, or cleared over 500 devices. FDA continues to receive an increasing number of marketing submissions as well as pre-submissions for these enabled medical devices. The traditional approach to the regulation of these hardware-based medical devices is not well suited for this faster iterative design and development and type of validation used for these software functions. So FDA's traditional paradigm of medical device regulation is not designed for these adaptive AI and ML technologies, right? And so FDA, they have the framework to approve these devices and work with it. So they've got to be creative to help industry make sure that the treatments that they're delivering are as late and up to date and state of the art as they can be. So here are some devices that went through, we talked about, and the point of these slides is to say, if you're a PMA, if you're a pacemaker delivering neuromodulation, implanted drug delivery system, and you require a PMA, those timelines are great, right? If you're a 510(k), your ablation, balloon dilation, certain imaging, your timeline and pathway to market is a little bit quicker. And so understanding the type of devices that go under a PMA and then the type of treatments, right, life-sustaining treatments that they could provide, and the sometimes 180 could be a year review of changes at least, and that's not considering the documentation required to provide to FDA when you make those changes. We're stuck, right? We don't want to be always 2 to 3 years behind in the treatment that's being provided to patients. And so FDA understands this, and working within their current framework, we're going to start to see some evolution in their thinking on how they are going to allow industry to provide changes in the marketplace while staying safe and effective. So In 2019, FDA had a discussion paper, and then a 2021 plan action followed that started to provide the idea of what's called a predetermined change control plan. Now, this is going to be very important language for clients who have an AI ML device. It's really helpful for anybody, but very important for AI and ML. And under this plan, manufacturers are required to submit specific things, a detailed description of the specific plan device modifications, the methodology to develop, validate, and implement these modifications in a manner that will ensure the continued safety and effectiveness of the devices, right? FDA, anytime they're looking at a change, they're making sure that that safe and effective determination made prior still stands. And so they need to have data, they need to have proper evidence that shows that, yes, you can place this change device on the marketplace, because if not, it could be an adulterated device. And then also FDA wants to know an impact assessment. So this is a future-looking thing for FDA. So they want an impact assessment to assess the benefits and risks of planned modifications and risk mitigations. So along comes a guidance document. So on April 3rd, 2023, there was a draft guidance. It's already been finalized December 4th. And it's about making submission recommendations for a predetermined change control plan for artificial intelligence, machine learning enabled device software functions. Now, what's important to know about this is a tool that can be utilized and should be utilized to allow changes to be made after market authorization. It's whether it's a 510(k), a de novo, or a PMA, changes made to a device that do not require pre-approval from FDA. And so now we're getting FDA's attempt to say, hey, we understand that AI ML is changing. It has the ability to treat patients more efficiently, more effectively. So let's get the documentation together beforehand. This is often done during your market submission, and say, show us what kind of changes you will make, what the evidence you will gather are, and give us an impact assessment. So we can say, yes, you can make these changes without any input from FDA. And that's a huge benefit. Honestly, this can save months or years of time to market, and you can imagine the benefits for patients. And so what does this give you? Well, better predictability for launch timing. If you're representing industry, you have to understand every month, every 2 months, all of that is burned in their capital. And that's an important decision, whether we like to admit it or not, on how things can be moved forward, because every company has a finite amount of money. So if you can be more predictable in the ability to launch new capabilities, your business is going to be more predictable. So there's cost savings associated with less regulatory submissions. And ultimately, what those two lead to is more development, more market benefits. And in the end, all of this will allow patients to realize the benefits of aggregated data sooner, right? As we kicked off with, there's so much data being gathered. There is so much good information. And if companies can point to the type of data they're going to collect, the way it's going to be used to improve their device, they can launch those changes to patients much sooner than they could have in the past. So Mark touched a little bit on the next couple slides that I have that I'm going to move through pretty quickly. But this is not the only thing that FDA has done to allow for innovation. They have talked, there's guidance, there's 21st Century Cures Act on certain types of software that don't require FDA oversight. And what that allows is, if someone's going to be putting together an application to assist physicians, as long as they meet certain elements, they can get that device, that software, that application on market much sooner while it's still fresh, right? While it's still a very useful technology, and it allows physicians to start taking advantage of certain devices quicker. And so that stems from the 21st Century Cures Act. And that's really important to note that, this act of Congress was really getting in front of AI almost 9 years ago. And so there is good legislation that can be crafted that helps the FDA and helps industry meet their goals of treating patients while remaining safe and effective. And so I'm just going to close with this. Remember, AI is complex. The laws and regulations lag behind. And that can be a good thing too, right? If we're trying to put it into a box and regulate everything, it might not be able to result in the best treatment for patients. But it is complex, and the language doesn't always exist. And so being able to interpret your product to FDA and relate it as well as you can to existing framework is going to be a great predictor of success. Device classification is difficult because of the ever-changing capabilities of AI and ML and the complex algorithms. You might not have a great predicate in the market. Proving safety and efficacy, making sure you've got a clinical study, if required, that has opened as much of the capabilities of your device as possible, because ultimately you get to market what you prove. Post-market, making sure that you've got a post-market change control plan in place so that you can deliver care to patients as soon as it's available, and being able to predict the type of changes you want to make will allow better treatment and better predictability. And I just want to put a quick bullet in on advertising and promotion, because that's where that's where FDA most sees the way that you're going to present your device, and making sure you have a plan in place for compliant, non-misleading advertising and promotion will allow you to safely market your device. Um, you'll see these slides. There's some considerations here on mitigating device risks. Obviously, things like cybersecurity, a good quality system. If your AI device is connected, you're going to FDA is going to want to know that you can withstand attacks, for example, and you're going to have requisite documentation to prove that. So just some things as you get into a development stage you want to consider. And I'll close with, be open with FDA. Communicate early, communicate often. If you have a very unique or novel treatment device or whatever it is, algorithm, get in front of FDA. They're always receptive to a informational pre-submission, a pre-submission where you can let them know about your device and have a good question and answer session. Always be honest. The FDA knows that AI is important. The government knows AI is important, and it's not going away. So partnering now from an industry standpoint also allows you to have a seat at the table. And so if there's any questions, I'm happy to take them now. Can also take them during the session at the end on the panel. But thank you, and I really hope that we all realize that FDA is working hard to understand AI, and the more we partner with FDA, the better they'll understand it.
Absolutely. Thank you so much, Nate. So we'll save those questions till the end so that we can keep on time here. And next up, we have Paul Rothermel with Privacy and Consumer Considerations. Paul specializes in privacy, cybersecurity, and healthcare compliance. Paul is senior attorney at Gardner Law, where he advises medical device and pharmaceutical companies on HIPAA, GDPR, and CCPA. Paul focuses on interpreting and applying privacy and security and cybersecurity laws, regulations, and standards to help his clients navigate evolving regulatory challenges, as well as general healthcare compliance matters. Thanks for being here this morning, Paul.
Thank you. Hi, good morning, everyone. I'm happy you can join us and talk about AI. It's an exciting topic. A lot is happening. And of course, if you're at all familiar with privacy, it's a busy area as well. And so privacy and AI definitely overlap in some really significant ways. And we'll see that through some of the slides I'll share and conversation topics. So we'll start here with and we'll focus on the US. There's obviously a lot of AI and privacy developments worldwide that we could talk about. We'll focus on the US today. But we do have to at least reference at some points what is happening and how that's impacting the US elsewhere. We'll focus on what are the privacy rules and laws in the US doing about AI, and how has the US started to regulate AI from a consumer perspective. So we'll get that kind of look at things here. We'll end with a few examples of enforcement, and typically we're seeing enforcement more from the federal government around AI. As Mark mentioned, the FTC has been active in that area, so we'll talk briefly about that as well. So let's go ahead and dive in. So what is happening in the U.S. right now is primarily direct regulation of AI is coming from the state level. So we're seeing the federal government. There's some activity at the executive orders we're seeing coming from the previous administration, trying to set some general safeguards and so forth that the federal government needs to align with around AI, and then some rolling back of that and kind of loosening of those rules in the current administration. Beyond that, though, we're not seeing heavy momentum at the federal level to regulate or restrict or kind of put up rules of the road generally for AI in the private sector. What we are seeing, though, are certain states are starting to jump in and try to regulate certain aspects of AI. So we're seeing things like the Utah AI Policy Act. California has a similar rule, and these are focused on what's called generative AI. And I believe Mark mentioned that in his presentation that generative AI is this AI that you typically would use like ChatGPT or um, Google Gemini, these different tools that you kind of prompt and work with and kind of develop, generate results and outputs. So there's rules that are starting to develop around those, and we've even had two laws pass so far, and more to come on that. And then uniquely right now, Colorado has already started regulating AI more broadly. So if you are following along with that set of rules, it does echo some of the things we're seeing in Europe. So Europe has passed an AI Act as of some time ago now, actually, and gradually that is implementing and becoming effective. But the idea there is that AI as a whole, these kind of AI systems as they're defined, need some regulation, some curbing, some control to protect individuals from the potential risks, whether that's some privacy concerns, but more main concerns are around discrimination or misuse of AI to make decisions where the individual might not have an opportunity to appeal that decision or have some input or things along those lines. HIPAA, of course, the Health Insurance Portability and Accountability Act, and all of the amendments of that through high tech and so forth, and the regulations that are implemented around that also have a lot to say about patient privacy and how that's how information is used, and that impacts AI as well. And then, of course, the Federal Trade Commission Act doesn't directly regulate AI in any way, but a lot of activity around AI involves consumers and it impacts consumers. So we're seeing an interest from the Federal Trade Commission in how do we protect consumers from misuse of AI or potentially, deceptive activity with AI or other consumer protection concerns. So we'll talk some about that as well. On top of this, there are many state privacy laws that have passed just in the past 5, 6 years now. California kind of led the way with the California Consumer Privacy Act, but then many other states fell in line and found their own versions of privacy laws of varying levels, and all of them have a slightly different take on things. So we're seeing a lot of patchwork, sort of a patchwork, as we might hear it called, of privacy law developing. What's interesting about this and how it relates to AI, and we'll talk about a couple of examples coming here. There's an element of these privacy laws in many cases that regulates artificial intelligence use or AI use through this idea of automated decision-making tools. And so there's some regulation that overlaps between privacy regulation at the state level and these kind of AI protections that we're talking about today. And I also noted here there's a few states that are focused on consumer health data. So Washington is a great example of this, but New York just passed a bill similar to this. And also in Connecticut, we saw an amendment to their privacy law a couple of years ago. And then Nevada that have these consumer health data laws that are really specifically focused at health information that falls outside of HIPAA's protections. And, if you're familiar with HIPAA, it has a very specific sectoral bent towards interaction with insurance and how is insurance billed. So providers that interact with insurance are regulated by HIPAA, but there's a broad swath of organizations and companies and entities that handle health information frequently or regularly. And you might think of like those health and wellness apps that you use on your phone, other things along those lines. Those would be regulated generally by these consumer health data laws. And that fills this gap between HIPAA and these kind of these rules that don't, or these apps and uses that don't actually fall under the HIPAA rules. So what does HIPAA have to do with AI? And that I think this is an interesting starting point because HIPAA is not generally thought of as a AI regulation, and it really is not, but it has an impact, a significant impact on the health industry. Most often in the medical device space and the pharmaceutical space where I kind of live is there's a lot of clinical trial and other kind of data collection activity that pulls data in and de-identifies it for use to develop a product or to further demonstrate the efficacy of products to the FDA, as Nate was talking about earlier. So there's ways to collect PHI, protected health information, and use it in AI functions, whether that's using it to feed a model or even on the kind of healthcare provider side, you can use AI to benefit patients through these clinical decision-making tools or even other kinds of more direct uses. But there needs to be, anytime you use patient information under HIPAA, there needs to be a basis for that. There's a series of permitted uses and disclosures that HIPAA allows, and some of those include things like use for healthcare operations or treatment, uses for payment, these various permitted uses or disclosures of PHI. But if there isn't one identified and you can't align the use of that data with one of these exceptions, well, then you have a restriction and you have to consider, do we need to get patient authorization? Does the patient have to consent to this use of data? Or can we de-identify data in a way that we're no longer subject to HIPAA? So we have these federal regulations that limit use of PHI, and that impacts AI directly as we're trying to determine what are the appropriate uses of patient information. Um, Federal Trade Commission, also at the federal level, well, we haven't really seen direct regulation in the sense that the FTC is not rulemaking, they're not writing regulations around artificial intelligence or privacy. We did see in the last administration, at least, significant activity around especially the use of data to create models that without, for example, adequate consent. So we saw some activity like enforcement against big tech or in some cases smaller tech, but really focused on how is data being collected? Is it properly used? Is there an adequate opt-in? And we'll talk about a couple of examples at the end of the presentation here of that kind of enforcement activity. But even just this week, the current administration has expressed a little bit of maybe a shift. We're still going to wait and see exactly what that looks like. But there's a concern of over-regulating AI or kind of limiting the ability to innovate. So there is a concern on that front that we're seeing expressed, and some of the prior guidance that the FTC has issued has been rolled back a little bit and sort of adjusted. So we're going to see probably a different emphasis, although the chair has also expressed to focus on consumer protection still, and AI is obviously a significant potential threat to consumers if used improperly. So there will be some correction, but probably some of the same kinds of activity going forward. Now, at the state level, we're seeing, again, not a lot of activity in terms of direct regulation, but it's developing. Colorado already has its own AI Act, kind of leading the way, regulating AI broadly. So it defines an AI system here to mean any machine-based system that for any explicit or implicit objective infers from the inputs the system receives how to generate outputs, including content, decisions, predictions, or recommendations that can influence physical or virtual environments. Now that's a lot of words and it means something, right? And it sounds like a pretty broad definition if you kind of just read it. And it is, it's a very broad definition. So the idea is it takes in all sorts of potential and it's an attempt, I think, to be forward looking and think about what might AI look like, a year, 5 years, 10 years from now. So it's broadly defined. And the attempt is to try to cover potential uses of AI or similar kinds of systems in the future that don't necessarily fit a more narrow definition at this point. And then there's this concept of high risk AI systems that's baked into this law that focuses more of the regulatory burden on those kinds of systems. So we'll talk a little bit more about that. So a high risk artificial intelligence system means any AI system that when deployed makes or is a substantial factor in making, quote, a consequential decision. So a consequential decision is a big emphasis point in the Colorado AI Act. And I will note one of the interesting things with this law is it was passed, it's on the books. However, there's some concern right now, the governor of Colorado, and there's been a task force assigned to look at this law and evaluate it and think about how do we improve this law? Because there's shortly after it was passed, there was a lot of discussion from industry and from lawmakers. How do we actually interpret some of these requirements? They're very broad and in some ways vague at points, like this phrase consequential decision. So there's been an ongoing discussion, and there was a report released in February from the Colorado this task force assigned to look at the law, criticizing and raising some issues that could be addressed through amendment. So we're probably going to see that happen before much more, enforcement or the Attorney General issues regulations. We'll probably see some amendment or at least some discussion of some amendments before that happens. But part of the requirements under this law are that developers, so those who create or develop a high-risk AI system, they have to provide those who actually use the system, the deployer. So let's say you are a tech company providing some sort of clinical decision support or something to a healthcare provider, to a hospital. You would need to, as part of sharing that or providing that system to the hospital, various kind of transparency statements about how would this potentially be used, potential harmful or inappropriate uses of the software or the AI system. Um, how did you train it to some degree? So there's some very kind of, I won't go through the whole list here, and there's more, but some of these are examples of information that would have to be shared by the developer of that system with the deployer. So just something else to note, there's a few exemptions, and I think I just repeated the high-risk AI system definition, but below that, there's this exemption. So some of the exemptions that we would look at, certain types of data use for HIPAA-regulated entities. Um, for example, if it's a non-high risk healthcare recommendation, it's hard to, again, know exactly what that means, but there are intended to be some exemptions for covered entities like a hospital or a healthcare provider that uses AI in certain contexts. Um, Also, certain technologies that are approved and certified or cleared by, for example, the FDA or other federal agencies, if those standards are substantially equivalent, whatever that means, but we again have some exemption. So those kinds of things are hopefully going to be clarified further when we see if we see any amendment to the law. But I do want to point out there are some exemptions available, particularly in the healthcare front. In California, we have the generative AI law that I mentioned earlier. And this defines artificial intelligence fairly similarly. You see that same idea of a machine-based system, um, has explicit or implicit objectives, infers from input it receives to generate outputs that influence, again, this phrase of physical or virtual environments. And then it defines generative AI in a more specific way. And these generative AI rules are largely focused on how do we protect consumers and ensure that privacy or not privacy, but consumers are protected from potential misuses, or at least there's transparency around what is this AI designed to do? How does it function? What kinds of data were used to train that device? And on the privacy front in California as well, so the CCPA and other state laws, but we'll focus on the CCPA here. There's also this concept in the privacy rules, as I noted right early on in the presentation, that these these privacy rules also regulate AI in sort of a interesting way where we have data inputs. So obviously use of data is regulated. So what kind of data is used to train models is relevant. Is it personal information? Should you have consent, or are there other bases, de-identification, for example, to use that data? But also on the other end, um, many of these rules address the use of what's called automated decision-making technology. And that is particularly focused on things like profiling. So using broad sets of data about an individual to draw and infer conclusions about them. So you might have, you know, 99 data points and you're missing one data point. Well, using a machine learning process, you might infer that 100th data point about an individual and profile them in a way. And when what the rules are most concerned about is when that profiling leads to a decision. So you might have a healthcare decision, or insurance eligibility decision, various other kinds of activities that companies might use creditworthiness, et cetera. And those elements of data are not only collected, but then assumed based on a machine learning type of activity. So California and many other states have addressed automated decision making through their privacy rules. So as I noted on the previous page, the Attorney General, and I think I just glossed over this, but the Attorney General in California is authorized to make rules and particularly around automated decision-making technology. So we do have a proposed regulation that's in draft already covering this. And it notes, we noted in the Colorado discussion that there is vagueness around this idea of a significant decision. Well, in California, they've started defining that in their draft regulations, just to give us an idea of what that means. For purposes of this article, significant decision means a decision using information that, there's some exceptions, that results in access to, provision, or denial of, and I'll just highlight here, insurance, healthcare services, or essential goods and services, and medicine is captured in parentheses there. So these are some examples of what California is thinking about in its draft regulations, including in a significant decision, as far as what makes an AI system that's regulated by this privacy law. And with that, of course, comes various rights. So if there is an automated decision making technology that's used to make a significant decision, that typically means that individual consumers have opt-out rights unless there are certain other criteria met. For example, you would have to allow a human reviewer, an appealable decision made by a human reviewer, in some cases to avoid having opt-out apply, et cetera. So there's ways that California is thinking about consumer protection in this front. So I'll kind of speed through this part, but again, consent may be appropriate to use personal data to do these kind of algorithmic training activities. You can see that in many, many privacy laws around the country and the state level. So I'll just kind of highlight here a recap of this. So use of personal data to train AI, a very significant part of privacy and its impact on AI. Potentially, you could have a breach, and I'll mention this just at a high level, but if you use an AI system and your organization puts information into, say, a generative AI tool, there's always a risk there that that data that's shared with that third party is misused, there could be a breach. You might be inadvertently sharing it across borders through, this is most relevant, for example, let's say you're in Florida and you're dealing with a rule that restricts non-continental US use of this data. There's some of those kinds of rules that are becoming more common. Or if you're in Europe and sharing across the Atlantic into the US, those kinds of data sharing activities can be on their own violative of privacy laws or even result in data breaches, et cetera. So there's always that concern when it comes to AI use, especially by companies or entities that handle personal information and patient information. We mentioned the automated decision making and how that can, in a way, be a privacy violation. For example, profiling, that inference of data about an individual, or making significant decisions about individuals using those tools. And then, of course, if you are in an enterprise, that's using AI, if you kind of go out and individually use an AI system and plug in data, et cetera, you typically don't have protections. That data usually then is owned by that organization that provides the tool. So if you go and use ChatGPT on the internet on your own, putting personal information or other things into that AI that belongs to the company or to those individuals could be a privacy violation. So we always look to have our clients use enterprise agreements with those AI tools and ensure that privacy protections are incorporated, IP protections, and so on. So those are all considerations when using AI as a part of your work. So I'll just close with a few examples and some case guidance that we're seeing. California, typically does have a strong interest in AI and kind of these emerging technologies, and is in some ways leading the way on regulation of privacy and AI and other related activities. So there was a recent legal advisory that the Attorney General released that's really focused on AI and how it's used in the healthcare sector. And it's not making new law, it's simply pointing to various existing laws and highlighting some of the concerns that the Attorney General is identifying and concerned about, and highlighting them for industry. Some of the considerations from this that I'll point out, there's more there, and I encourage you to look at that if you're curious about this topic. There's a lot of kind of legal theory that's discussed. But some considerations to highlight, the AG was concerned about transparency, so patients knowing when and how their information is used to train AI, and how providers might use AI when making decisions about the patient. Concern about accuracy. So there's a very common use case of AI right now to draft patient notes. So you might even have devices that listen to your visit at the doctor or clinic, where you're automatically getting transcriptions of those visits, and even sometimes that data is automatically entered into records. So accuracy in that, and how is that disclosed to patients is a concern. Medical practice, just ensuring that healthcare provider decision making is still maintained by the healthcare provider, so that AI doesn't take the place of healthcare decision making. As Mark mentioned early on in this program, prohibitions on discrimination, so concern about individuals being disproportionately impacted by algorithmic decisions or activities there. And then this idea of informed consent, I think, is very interesting. So using informed consent principles that we typically see on the medical provider side, in the context of AI use. So if there's an AI tool that's being used to support treatment, what about informed consent? And is that being sought from the patient? And then I'll just mention briefly, although I think we're getting close to time here, just a couple of examples from the FTC. Um, there hasn't been a significant amount of enforcement on AI to date. There's been some. One of the emphases from the FTC, though, over the past few years, and even going back a decade or more, is privacy and cybersecurity enforcement from the Federal Trade Commission, and that's extended a little bit into AI, although the focus there has been more on kind of deceptive marketing of tools that use AI. But where it has impacted AI is this idea of data use. Um, is health data or other sensitive or even children's data used to train AI? And if so, is that data, properly collected, or shared or sold, depending on the context? So here's a couple of brief examples, and just focused on that idea of an unfair, deceptive act or practice, that the FTC is that's how the FTC is regulating these activities and bringing enforcement action. So you see here there was an order, um, basically banning a well-known healthcare company from sharing sensitive health data for advertising. And the reason I point that out is because advertising isn't what we're talking about here, but the concept of using or misusing sensitive health information is something the FTC has been focused on addressing, and I'm certain will continue to address due to the significant consumer impact of that activity. So you'll see here that this company had repeatedly promised to keep health information private and use it for certain purposes. And here it says for non-advertising purposes, but you can see how this would extend into things like artificial intelligence usage. And there's this concept of appropriate use and then usage that goes beyond that, and potentially could be a misuse of that data. Another similar kind of case, where the FTC brought a complaint against a company called Monument that supported folks that had a substance use disorder, and that was the focus of Monument Services. And at the same time, there were some privacy promises that were not being upheld, and the FTC took issue with that and brought some action against this company. Again, the focus being on sharing of sensitive health data or use of that data in a way that was not consented to by patients. So that, again, is a focus that the FTC has had over the past several years. And you'll see here that um, some of the things that were required based on these actions are identifying what user data was shared or you in this case shared, but sometimes could be misused, and then having that data deleted. There's even been cases where the FTC has required companies to delete the algorithm that they've used or created based on data, the data used are collected in an improper way. So sometimes even the product itself that's been developed using personal data becomes part of the enforcement so that the product is based on kind of like you could think of the fruit of the poison tree that we hear about in law school. It's that same concept, but with data. That algorithm might itself be not containing personal data, but it was created in a way that was inappropriate. So that algorithm has to be destroyed. And one thing that to keep in mind too, sometimes when it comes to privacy, we think of de-identification as this simple process where, for example, hashing is this idea of replacing certain values in data with a hash. So it scrambles certain parts of the data. Um, the FTC has been really clear that certain kinds of anonymization techniques that we're used to using, especially in the ad tech space for advertising technology, um, aren't necessarily anonymous. And so being aware of exactly what kinds of data is used in terms of AI training and other models, um, that is really key to understand what is actually regulated and what kind of data you're handling. So I'll close there. I think I'm right at time, so I'll pass it on to the next speaker.
All right, thank you so much, Paul. So next we have two speakers, Kelly Henderson and Dr. Brita Hansen, discussing scope of practice considerations for AI. Kelly and Dr. Hansen are both joining us today from Allina Health. Kelly is Vice President for Risk Services and Deputy Chief Legal Officer. She oversees risk management, insurance, workers' compensation, and all litigation matters. Dr. Hansen is a board-certified internist and clinical informaticist leading digital innovation at Allina, including the responsible use of AI in care delivery settings. Thank you both for speaking today on this exciting scope of practice topic.
All right, thank you for having me this morning. So as you can see, we are going to jointly give this talk and present both the MD and the JD perspective from within a healthcare organization, a provider organization. So I'm going to start with the MD perspective. As Molly mentioned, part of my role at Allina is overseeing the team of folks who does the evaluation and oversight of AI systems that we use in care delivery. So my portion of the talk is really going to focus on how we think about that as we are evaluating and using these systems. So I'm going to start again where others have already touched on this, but the basic question of what is artificial intelligence, particularly as we are looking at using these within healthcare organizations. So this is the definition we use at Allina Health. You can see here that artificial intelligence or AI refers to computational systems or algorithms that can perform tasks, solve problems, or generate outputs in a way that mimics human intelligence. And this last clause is what our team, as we are doing this oversight work, has added to really reflect where AI is now as opposed to where AI has been in the past. And that is that current AI systems, particularly when we're thinking about generative AI and AI built off of large language models, are not limited by strict rules or explicit programming. So human beings are not defining every single if-then statement or programming in the chain. And so we think this is an important distinction of the types of AI models that are currently being used, and they require additional evaluation and oversight when we are using them. So if we take that last clause of that definition away, and I think others, I think Mark touched on this, that we have actually, in the broader definition of AI, been using AI within healthcare systems for decades. So at least as long as we have been using electronic health records within health systems, we have been using some form or another of AI. And so I often think about this as across the spectrum, and we've touched on this already a bit this morning. But I also have on the top of this slide that it's about choosing the right tool for the right job. So just because we have more advanced AI and generative AI now does not mean that we do not need the other forms of artificial intelligence that have existed for decades. So when we think across this spectrum, I think about starting with the basic forms of AI that are really rules-based. And this would be the opposite of the last clause we talked about before. These are always expert defined, explicitly coded. So human beings have made decisions about each portion of the rule. And so therefore, the outputs of these models are very targeted, they're deterministic, they're very predictable. If you put A, B, and C in, you're always going to get D out as your answer, for example. In the middle is the predictive or advanced analytics. And so these are much more statistically derived. And they may or may not be augmented by machine learning. So again, thinking back to, I think we talked earlier about those who have taken statistics in the past. Oftentimes these really basically just look like big math equations, right? And they almost always start out where people make decisions about what each factor going into the equation is and how heavily to weight one factor or another. When we start adding machine learning into this, we allow the model itself to learn and grow and to take into account new data as it emerges. So it may switch in and out different variables, it may weight different variables more or less. But generally speaking, with these types of models, we can actually look into them and see how the model has evolved and how it came up with its conclusions. So while it's a little bit more variable in its output and has some machine learning happening, it is not quite so much the black box that we see in more recent generative AI. So that brings us all the way to the far end of the spectrum of generative AI, or AI that's built on these very large language models, and they are generally trained to be able to adapt and grow as data changes. So these have much more generalized and variable output. So as any of you who have used ChatGPT have seen that you could, for example, give the same prompt on a couple of different occasions and receive at least slightly different answers or slightly different outputs depending on when you put it in, because things are changing. It's very similar to if I were to ask two of you the same question. If it was a complex enough question, you may both give me correct answers, but they are not likely to be exactly the same. So in the same way, the outputs of these models can be much more variable. So this slide here is a framework that my team goes back to over and over again whenever we are thinking about using an AI model. And, really, this applies to any computer system in general, but I will obviously think about it more in the context of an AI model. But we look at this importantly because if any one of these components or aspects of the whole system is not working, the whole thing is not going to work. It also, I think, when we're looking at evaluating the use of these systems, these are places where we have an ability to have some oversight of the system and some controls over the system to make sure that they are performing the way we intend them to and that they are safe and responsible. So we often think and worry these days that these new AI models, like I said, are somewhat of a black box, that we don't always know exactly how they're working or how they're reaching their conclusions. But that does not mean that we don't have any control over what they're doing and how they are used within our organizations. So we, first and foremost, the model has to have access to the right data in order for it to do what we want it to do and to avoid avoid some of the errors and problems that it can have. So we have some control over what data the AI model itself sees. Then there's the AI model itself, and we do have some ability, even if we don't always know exactly how it's working, to validate that the outputs that the model is giving are valid and appropriate. And then these last two things I think are particularly important. And sometimes when we look at computer systems, it does look like these last three things are all squished together. You kind of put data in and it does some things and then it spits out an action. But if you really pull it apart, we do have the opportunity along the chain to really, pause and make sure that each step is working and that it's doing what we want it to do. So the AI model is going to come up with an output. And when it puts that output out, the intent of that is to make a decision off of it. And as we, again, previous speakers have already talked about this, that there are really guardrails in healthcare right now that we do not want these AI models doing the medical decision making. So we have to think very carefully about when the model is putting its output out, who is it going to make a decision? Oftentimes it's going to a person like me, a physician who is expected to make a decision or have some oversight of it before we then take action. So there's a lot of room for control there and making sure we are thinking through that part. And then finally, what actions do we intend to take off of that decision? And who's doing that? Are they properly resourced to be able to do that? So this is an area that my team spends a lot of time on, and that is the evaluation of these systems. So there's a lot of stuff coming at us all the time. We have lots of things we want to solve in our healthcare systems with, and there's a lot of promise that AI can help with them, but how do we make sure that they are doing what we want them to do, they're effective, and that they are used responsibly? So this here on this slide is the framework that Alina has come up with at a high level for how we evaluate AI products that we are thinking about using. So you can see we've developed it into a four categories to consider: their clinical utility and safety, bias, equity and fairness, privacy and security, and human considerations. So under each of these categories, we have developed a set of guiding principles. So there's some summary principles here on this slide. And then under that, we have a set of evaluation questions. And we go through that questionnaire with usually the developer or vendor who has the AI product, and we go through all of that, and then that is evaluated by a multidisciplinary group within Alina. So that group contains clinicians like myself. It has IT experts, legal and compliance, and we have medical ethics representation. So it's this diverse group that together looks through the questionnaire and makes a decision about whether this meets our standards to bring into our environment. So where did this come from? I think I'm not going to go into this too much because I think others have touched on it. But in terms of where we are getting our guidance as far as having a framework for how to do this evaluation, we have gotten some guidance from the federal government. I will say that at Alina, we put ours into place before any of these regulatory guidance were starting to come. I think ours came out in early 2023. One organization that we used for initial guidance, and I think is an organization worth kind of keeping an eye on, is known as CHAI, or the Coalition for Health AI. And they have also a very nice framework that is available to align with. But as others have mentioned, under the Biden administration in late 2023, there was an executive order about safe, secure, and trustworthy development and use of AI. And from that came what is often called the FAVES model, which stands for fair, appropriate, valid, effective, and safe. So after this came out, we were hearing a lot of this within healthcare organizations and a lot of attempt to align with this. And we at Allina, as many others have, did a crosswalk to make sure that our framework matched this. And as you can see, there's a lot of similarity. But of course, that specific executive order under the new administration is no longer valid. But obviously, we still want to ensure that we have some sort of framework in place to continue to evaluate appropriateness and responsible use. And again, others have mentioned this NIST framework that came out last July. So I think within healthcare organizations, we're seeing a little bit of a shift. So, you know, a year ago, there was a lot more talk about the FAVES framework, and now there's a lot more alignment with the NIST framework. There's a lot of similarities. So there's just a lot of ongoing cross-checking to be sure that any evaluation framework we use within our organization is aligned to these. So what are we using generative AI for in health systems right now? So there's a lot of consensus that these are kind of the categories of things that AI is currently very good at. So things around drafting text, this has been brought up already this morning, gathering and synthesizing information, translating content and tailoring communication, and automating actions. When we think about a typical clinical encounter, so when I go in to see a patient or when most clinicians are in with a patient, we follow a pretty standard set of a standard approach of how we do it, things that were drilled into us back in medical school. We have a very common practice that we use to make our medical decisions and then carry them out. So the first step is typically gathering and synthesizing information. And this is a place, again, where AI is very helpful to us because it really helps us to sort through massive amounts of information. So that example Mark gave earlier of the physician who was having a stroke, and the AI system was able to look through thousands of images very quickly and surface the most important things quickly. That is the type of thing where AI can be very helpful to augment our abilities because we can't possibly do it that quickly. And there's just so much data for us to sort through sometimes. And then we take that information, and this is the very crucial part where we are doing our medical decision making and generating an assessment and plan. And I have put this big red circle around there because in general, not only are our general the regulatory framework is moving us away from doing this, but I think in general, our AI systems are not quite there with this yet, and certainly public acceptance of this is not yet there yet. So we at Allina and elsewhere are putting a very strong line around this, that the medical decision making and oversight still needs to happen by a human being. But then after that, we do things with that medical decision making. We document what we've done, we take actions, and we communicate our assessment and plan. And again, all of these things, AI can really help to augment us, the human capabilities, and offload a lot of our work. To go back to this initial framework that I said I put forth earlier on, this is how our team will go through this every single time, so that when we have an actual AI product in front of us, we'll look at all of these parts. So where's the data coming from? How does the model itself work? Who is the decision maker, and is it the appropriate decision maker at the right time? And then finally, what are the intended actions that are meant to be taken with the output? And so again, I think it's very important for us to make sure that the ears are working well and working responsibly, that we systematically go through each of these steps. And then finally, my final slide here is just kind of unpacking a couple of those concepts from the previous slide that I think are particularly important to note when we are looking at these systems in healthcare. First is just the access that the AI model, the data that the AI model has access to. So this is our classic garbage in, garbage out problem. But when it's with these AI models with large language models that they're trained on, this is kind of like garbage in, garbage out on steroids, because now we're seeing that even small amounts, things that would seem like small cognitive errors or small amounts of bias can be amplified tremendously if we're not careful for it. So I really appreciate this quote about the fact that our AI models have access to all of this data that reflects the world's beauty, ugliness, and cruelty, but we kind of expect it to only reflect back the beauty. So we have to be very careful that we're mitigating this. A second issue here is what we call the alignment problem, and that is that the AI models are not always solving the exact problem that we're hoping that it will solve. And this, again, is a function of the fact that it has access to data, only has access to the data that it has access to. So if there is, if we can't measure the thing we want it to be solving, it is hard for the AI model to give us the answer we want. So you can see some examples there. But that paper that I have put on the middle of the slide here from the science is a case study that really helps reflect both of these first things. So the impact of bias that exists in the training data and also the alignment problem. So in this case, this was actually an algorithm used at United Healthcare, and to their credit, they really have made this quite public, and there's been a lot of discussion about this, which I think has really served as a good learning case for us all. But essentially, they were using a large data set to predict future need for healthcare, and it turned out that, a lot of the actions that we as physicians take, even if it's relatively small, there's bias baked into that data. And so that the prediction was not what we had hoped it would be. So racial bias ended up showing up and becoming amplified through this algorithm. So it's a very good case study if you're interested. And then finally, I think it's so important, and I brought this up before, that we really consider where the output of the AI model is going and who the decision maker is, and that we really think about just best practices we've done for years and years, but it still holds true that we want to make sure that we are putting these best practices into place to avoid bias and other cognitive errors in the decision-making process. I think that is the end of my section, and I'll get on to Kelly and the
lawyers.
lawyers.
I don't know if you could help take down Brita's slides so I can put mine up. I reordered them a little bit, and I can maybe take control then. Thank you. Okay, so I think what's really interesting here is the intersection between the law and AI. And I think what we're seeing is there's sort of a spectrum of lawyer knowledge on this topic. And so I was curious because I wanted to know, what do lawyers know about AI? And so I Googled it, and the AI generated Google statement was, while there's a growing awareness of AI among lawyers, a significant portion still lack a deep understanding of the capabilities and limitations, with many only having a basic knowledge of how AI can be used in legal practice, particularly in areas of document review, legal research. However, increasingly savvy lawyers are actively learning about AI to leverage its potential and efficiency gains for better client service. And so I think what that really reflects is that there's a business piece of it that, lawyers can incorporate. And I think that given that AI is such a wide and varied topic, it can also, it's the substance of our practice and how do we manage it. And, if any of you remember the cat meme from the early pandemic, where you had the "I am not a cat" technical difficulties, I think it just really illustrated the variety of kind of capabilities that lawyers have in the area of technology. And if you haven't seen this meme, do yourself a favor and Google "I am not a cat lawyer," and it should come up for you. But I think, we in this profession have a sort of wide range of technological capabilities, and some of that's generational. Some of that is personal preference for kind of having low tech. And, you then have to build in, educating your lawmakers to make sure your lawmakers who are just, citizens, are thinking about these things in a thoughtful and broad-based manner. And then your judges, because, if you have inconsistency among judges and inconsistency among states, it can be really problematic to really know how to have a consistent approach about this. And so my area is medical malpractice primarily. And I thought about, the AI world in the context of how would that manifest in medical malpractice. And I think, as Dr. Hansen pointed out, there's so much great, capability and beauty that we can have from AI. I mean, and even, as we were talking earlier in the FDA space too, the devices that are coming out that will help, catch a stroke at the time it's happening, where that will save someone's ability to walk or talk or interact with others. And we've found that AI can do better in diagnosing and treating decisions, and even be more empathetic than physicians in some instances. I think one of the questions for us is how will AI, the use of it, establish or not establish the standard of care in medicine? So what is going to be adopted sort of writ large? What are we going to expect for our physicians to do? Are we going to expect them to use AI? Are we going to say you have to use it as an augmentative tool, as Dr. Hansen described, or is it going to be expected in the future that no, we really just want the machine who knows everything to do that, and not use your independent clinical judgment? I think that there can be, trust issues in, well, how did the algorithm come to what it is, and making sure that there is common acceptance of that too, because it's not just the physicians that have to accept the answers, but the patients, and communicating the patients how those decisions and how those diagnoses are being made. And then there's always obviously the risk of over-reliance on AI. I think there's a lot of folks who maybe rely a lot on ChatGPT to draft an email or to do certain things. And, you don't want to lose the independent, experienced clinical judgment. And then I think in the med mal space, the questions will be, should you have relied on the AI, or should you have overridden the AI? And this may not be right for conversation right today, but that in the future, as we think about how we defend cases, or how we bring cases as plaintiffs and lawyers, what will that look like? And, I think kind of one way or another, unfortunately for physicians, someone will be sued. And I think that's part of the question of, what will the landscape be? And again, this brings in all kinds of other dynamics, like trust in institutions, trusts in physicians, trust in the healthcare system, and how are we augmenting and fostering greater transparency along those lines. So I just pulled out, from the litigation world, one area of AI and discovery, and I think that this also illustrates the complexity of just one portion of litigation. The Minnesota rules of civil procedure offer broad discovery, and so that will require greater collaboration when requests are made for attorneys to work with their risk management or their health departments, their health records departments, IT and software engineers. And I think what will be difficult in this is that the AI is not going to necessarily be replicable in the sense that there will be, once it's been spit out, you may not have a way to say, well, how did it get to that conclusion? And so that sort of, I don't want to call it mystery, but that lack of charting, as to where that went into each of those steps is going to be a new thing to have attorneys be accustomed to, because it's not going to be a physical, there's no retention of those things, and you're not able to replicate that. And what we're seeing a little bit of that is in the medical record. We have the medical record where, we often get requests for live demonstrations of the medical record. And what's hard about that is that with each update of the medical record, it's not being replicated, and each provider's view is customized to their preferences. And so with each upgrade, those views get erased. And so we never really can give you a live view of what it looked like 2 months ago, 3 months ago, or even 6 years ago. I mean, so I think in the AI, as an analogy, we won't be able to replicate what it looked like on March 20th, 2025. I think there's just a lack of legal precedent in this area, and that's going to complicate things in terms of educating your judges, and how do you educate your court on something that, again, you're going to have a wide variety of judges and attorneys who have varying levels of expertise in this area. So really, it will be a challenge, I think, going forward. I know we're at time for questions, but I just wanted to also kind of add in there the complexity of, especially in the discovery period, requests for AI vendors to be part of the lawsuit, and what role will they play, and what will their appetite be for that type of thing. Some of this information they may consider to be proprietary. And again, as we talked about earlier, the garbage in, garbage out. So if you're not using the algorithm in the way that it could be used to its best and highest use, that will give you a suboptimal outcome. And that may be something that a vendor will say, well, that's not on us, that's on the provider who put the wrong information in. We can maybe talk about this in another session, but just to kind of allude to what Paul was talking about in terms of the privacy of medical records, we use AI tools in that space in order to maintain, to facilitate monitoring of our people going into the records appropriately or inappropriately. And so we have an AI system that can flag misuse of the medical record. And we still use human judgment, obviously, to determine whether or not that was in fact a violation. But it also creates risk for the organization, because if you have people who are using the medical record inappropriately, that has to be disclosed to the patient, and then they have a private right of action against us. So there is a lot here, and I obviously want to leave time for questions for everyone. So I will conclude my part, because I see that we're over time, but I appreciate your willingness to dive in and explore these very difficult questions.
Great. Thank you both so much. Our final session today is a Q&A with 4 panelists, 3 of whom you've heard from already this morning, including Kelly Henderson and Dr. Brita Hansen, who just spoke, and Nate Downing, who spoke earlier. And then we're also fortunate to be joined by Dr. Chris Tignanelli. My apologies. Dr. Tignanelli is a tenured associate professor of surgery and AI expert at the University of Minnesota, where he wears many hats. Dr. Tignanelli's research focuses on clinical decision support systems, which we've discussed in many of our conversations today, and evaluating AI-enabled and non-AI-based CDS in order to improve delivery of evidence-based care. Dr. Tignanelli has published over 125 publications, and his program is the recipient of over $29 million in research funding. So I strongly encourage all of you today to go back to today's program website and read up on the longer biographies for all of our wonderful speakers, as my introductions have been radically abbreviated. So I will kick off with our first question today. And I'm going to direct this one to Dr. Tignanelli, who's just joined us. In a couple of minutes, could you describe to us what your priority has been as it relates to AI in healthcare, please?
Sure, happy to, and thank you for having me. Um, so I'm the scientific director of our program for clinical AI at University of Minnesota, and I'd say we probably have three main focuses when it comes to AI. Um, the first one is developing novel AI systems that can help solve problems in healthcare. And a lot of times those are brought to us by your pure clinical practicing clinicians, and not so much research clinicians like myself, but people who day in and day out, all they do is see patients. A lot of times they can very well identify like these are certain problems that we need help with. These are, well, anyway, yeah. So that's kind of one of them. The next one is how do we implement AI into practice in a trustworthy manner, and also improve the adoption and use of AI by clinicians. So how do we make it explainable? How do we allow the AI system to communicate with physician and be like, I have a certain amount of certainty in this prediction, or this is an area where there wasn't a lot of training data, so my certainty is 25%, for example. How do you actually do that? And then the last piece is really around monitoring deployed AI. What are best practices around monitoring deployed AI solutions? How do we decide when AI needs to be turned off and optimized? Where is that threshold? There's no formal guidance out there right now. So I say those are kind of the main pieces that we're working in.
Great. Thank you so much for that overview. My next question I'm going to direct towards Nate. And please, everyone in the audience, continue to send your questions in the chat if you would like to, or if you would like to ask your question yourself, you may raise your hand and we can call on you and you can direct your question to the speakers as well. So Nate, you presented market pathway challenges with some of the descriptive use cases for medical devices in your talk. What do you see as the biggest challenge for getting approval for an AI ML medical product?
Yeah, I think the biggest challenge is being able to communicate what your device does so you can have predictability. There's going to be a pathway, right? But if that pathway is a PMA and it didn't have to be, you're going to have multiple years and many millions of dollars more than if you could have found a different pathway. And so if you can get in front of FDA early and share your capabilities, really maximize your story, if you will, and start to walk FDA down that path and understand the risks and mitigation of risks, then you can find a pathway earlier on, whether it's de novo or 510K, and really pushing for 510K where you can. That's going to ease a lot of work on the back end as well as give predictability, right? If you're a startup, it's very hard to overemphasize the difference between being able to launch in 18 months versus 4 years, right? Like one, you might not even be able to do at all. 18 months, you might be able to do so. And so getting it right early on and finding your right market pathway that utilizes the full capabilities of your device for as much as you can is a challenge. But once you get it right, then you have predictability. Even if you think about investors, they like to know that if you have a set path, it's much easier for them to invest in your device and to understand that, ultimately you should see market utilization of your device, which obviously is something they're looking for. And so that's the biggest challenge, but it's also the biggest benefit if you can figure it out early, because then you can show a lot of, like I said, investors, but also just the business predictability is so great when you have an early identified regulatory strategy.
Thank you. That's great advice and background information. So my next question is coming in directed for Kelly Henderson. When speaking about the framework that Alina applies, in what Dr. Hansen and you presented about Alina's very focused and stepwise approach to determining appropriate use of AI in CDS, for example, how would you balance bringing in a model that is maybe more closed and protective of not making accidental disclosures to an outside generative model or generative model. And if you were to use something that's in a closed universe within the enterprise alone, how would you balance the benefits or the risks that may come to the individual patient by choosing a closed model system?
Yeah, I think that's a really good question. And I think that's one that would require a lot of discussion with our physician advisors, because I think that becomes, I think the centrality of patient care is the thing that we always have to keep in mind. And so we have to balance the what's best for our patient population more so than what's the legal risk. I think I always want, patient care to come first, and we can deal with the legal risks later. And, I would welcome Dr. Hansen's thoughts on this too, but it seems to me that when making that sort of decision between an open versus closed system, that really needs a lot of clinical input and kind of that enterprise risk lens.
Yeah, I'd agree. I mean, I think this is, why we've set up the system or the structure that we have at Alina, to make sure we have the multidisciplinary group who kind of looks through all of this, and then, really examining, where is the output going, and, what kind of oversight is there over that output of the model. So it's very important in these cases.
Great. Thank you both so much. And for Doctors Tignanelli and Hansen, can you please give your thoughts on the role of the legal system and your use of AI tools in your practice? Does the specter of medical malpractice concern you or not?
Sure, I'm happy to go. It definitely concerns us. It's kind of like a double-edged sword. Like we've used risk prediction models or like scoring systems. You get 2 points if you have this, you get 3 points if you have this, and if you have more than 7 points, you need XYZ treatment, something like that. They've done that in medicine for a long time. AI is just the next generation of that. The reality is that, so, using these systems is kind of already embedded in medicine. And the reality is that a lot of AI systems are coming out and they're getting approved. And there hasn't been a lot of clinical trials yet in AI. But there's like a JAMA open paper that showed, I think, like 40 something. This is a couple of years ago, so there's probably more, but maybe there's 100 clinical trials in AI. But the reality is that eventually AI systems are going to become standard of care. And then the risk that I worry about is like, what do you do if either your system doesn't buy the AI system because the health system's like, oh, it's too expensive, we're not going to buy it, and then a patient has a harm? Is the system liable because you didn't give them optimal care, so you didn't have access to that system? Or if you do, you get the AI system and you don't follow the AI system's prediction, what liability are you taking? Because AI is not going to be perfect. You're never going to see an AI system with an AU rock of 1.0 and 100% accuracy. So, what happens when we, the clinician, disagree with the AI and we're pretty confident that we're right? How do you go about doing that, and how do you mitigate your risk there? So those are the pieces I really worry about.
Yeah, and I mean, I think again, it's important to think about this along the spectrum, that we have had forms of AI for a very long time. So some of the very basic tenets we've used for a long time still hold. And I think the thing with the more, modern AI systems is that the risk of automation bias becomes greater and greater, but that's existed for a long time. So it's very important to make sure that we are training, educating our clinicians about the risk of automation bias, and then also, just good documentation around why you have adopted the recommendations, the output of the system.
Great, thank you both. And that's a nice segue into my next question. Dr. Hansen, you've alluded many times as to how long AI has been around, and Mark Gardner opened us up talking about this. And if I recall from my training time, there was a discussion of these subcategories of these models. And it's my recollection that AI has truthfully been around since the 1950s. So my next question is for Nate. It's a data question. What do you think the tipping point has been in the data community that has created such a hubbub around AI today? And why did healthcare suddenly adopt it now?
Yeah, I mean, I think, it's been around, but the capabilities to be able to take all those data and integrate with complex algorithms and have the individuals with knowledge creating the systems and many companies doing it. So there's iterative work that goes on where people build off each other. That's increasing. And so, talking about what has changed with the data, I think there's just so much data that's constantly collected, right? If you take and implant a type of stimulator, for example, um, some of these stimulators are taking data on a constant basis of the spinal cord's reaction, for example, to stimulation and the output that's given. And so, yes, there's always been data in the 1950s, but you have millions of data points every day in a single patient right now. And so you just have more access to greater amounts of data that you can now run through these complex algorithms. And now you can show FDA, like, this is the data set I'm going to use. This is the algorithm that's going to be used to put whatever output we need. And here's the confines. And so I don't know if it's a tipping point necessarily. It's just you've gotten to a point now where you can show enough verification and validation on these AI-enabled devices that people can adopt them on a large scale. Whereas, I mean, I don't want to speak for the 1950s, but there probably just wasn't the systems in place, right, to be able to say, hey, let's predict where this patient's spine is going to end up after this exact implant based on this model is put into the spine. So I don't want to skirt the question, but I don't think it's a tipping point. I think it's a building and it's a governmental confidence, and the FDA has experts, and there's enough industry investing in it because it's not easy to invest in a medical device. And so all those combinations combined with the computing capabilities allow us to, start to see more and more treatment with AI-enabled devices.
Yeah, we used to live in a data limited world. Now we live in a hypothesis limited world, don't we? And we have so much data, it's become so much more affordable. It's become more accessible. Great. I have a question here that came in from the audience, and I'm going to direct this one to Kelly. So the question asker says, my organization moves slowly into AI, and we're a smaller organization. So we're told that we need to evaluate AI for various things, including efficacy and bias. But as a smaller organization, we're not going to necessarily be able to just get that answer directly from the vendor who's providing the system. How are we going to make those evaluations, particularly in the realm of bias? How would we look at a framework to do that?
Yeah, I think that's obviously a concern, and your limited resources will always play into the ability to make those decisions. I think we I think that there are models out there that can be used to help figure that out. What to be on the lookout for, how to look at the data sort of more broadly, and to say, we want to, sort of to Dr. Hansen's point earlier, we want to make sure that we're looking at a broader set of people rather than just a small subset of people who may have, kind of like in any sort of valid scientific study, you always want to make sure you're having a diverse group to look at. I think if the question is resources, I think one thing I would suggest is leaning in on your like the Minnesota Health Associate or Minnesota Hospital Association, or other sort of national groups that might have sort of like toolboxes for you to use and to consider. I think, I often will talk to my peers in other healthcare systems to kind of get a sense of what they're doing or how they've been doing it. I don't know, Dr. Hansen, if you have any suggestions too.
Yeah, absolutely. I mean, that's why I kind of mentioned those different frameworks in my talk. I think looking at the NIST framework, for example, could be very helpful. And then also check out the group CHAI, the Coalition for Health AI. They also have a nice framework and a lot of material, so you don't have to reinvent the wheel or start from scratch on these. And then I'd also say I would really encourage you to have these conversations with the vendors. I was on the vendor side, developing these types of systems for many years. We are very used to getting these types of questions and questionnaires, and your vendor should have people who do this, who fill out these forms. And if they aren't willing to do that or don't have answers to these questions, that would be a big red flag. So you can oftentimes just stop your evaluation right there if the vendor is not willing to have these discussions with you or has no answer to your questions.
One thing to also piggyback on that. So one of my other hats is I'm one of the co-chairs of mHealth Fairview's AI Oversight Committee. So we oversee all the vendor integrations that we do. A lot of times the vendors will let you can take a subset of your data and run it on the model and then see how does it actually perform, their solution in your patients. So that might, and if you don't have the resources to do that, I guess the other thing you could do is at least maybe not be the earliest adopter, let other institutions that do have those resources do that, and then also reach out to them, be like, hey, how did it work on your patients, et cetera. Because then at least you could get that kind of validation done. Because it's really important to make sure that it actually works like locally in the population that you're going to be deploying it on. Like Epic deployed their sepsis AI model, and they only developed that on like 3 hospitals across the country, and then it got implemented 100+ hospitals. And then people sat down and looked at it, they found it didn't perform anywhere near how it performed at the 3 original hospitals. So you really got to do that due diligence on your own patients before implementing any solutions.
That's great advice. Taking a subsample never hurts, right? And I imagine that would be another red flag if a vendor wouldn't allow you to run a test drive with some of your own data.
I would definitely see that as a flag. Yeah, and again, if you don't have the resources to, I'd ask them for a few reference customers and talk to the reference customers who've been using it.
Great. I always love getting vendor references.
Yeah.
Um, all right. The next question I have could be taken as a device question or a product question or a software question. So I'll throw it out there and ask Nate to start, but anyone else, please continue to jump in. This is so helpful. What are the biggest challenges and oversight of AI tools once they've been adopted within provider organizations or other areas of the healthcare sector that you've seen?
Yeah, so the ongoing change, I think, is one that's always difficult. I talked about there's some regulatory tools you can use to get in front. It's also a lot of tools will start as one thing, right? And they'll be classified as whatever that one thing is. And then, sometimes providers want to use it differently, the way that it's even maybe promoted, which, is not supposed to happen, but, sometimes sales reps will kind of see the broad capabilities and promote it there as well. And so it can become a different type of classification. You could have an adulterated device in AI very easily if you don't have a very strong change control plan. And physicians not regulated by FDA, but certainly industry and the device itself is regulated by FDA. And so if you are going to, have a kind of a lax change control plan and, people get really excited about their AI devices as they should, and the potential capabilities, but you could end up in the marketplace, with an adulterated device and not really have oversight and some of the answers that FDA might request when they see these capabilities unlocked are not always easy to have, right? Because those are going to take more data and more submissions potentially. So I would say being able to stick within whatever your approval, whatever your clearance is and your pre-controlled plan is the best way. And it's not always easy, especially as physicians or researchers get a hold of it and they see that the broad use case it's much bigger than you're able to market for. And so being able to stick in line and make sure that you follow the appropriate steps for study and approval of new indications or whatever it might be, is imperative, but it's not always easy, especially from a business perspective.
Yeah, on the oversight piece, another thing that I'm really worried about is like the FDA requires that all of these like software as a medical devices have a monitoring plan, like a continuous monitoring plan. But we work with a lot of these vendors, and they've told us that they don't have access to the data. So once they sell it to a couple of health systems, the health systems start deploying it. They don't have access to the data from those health systems, so they don't know how it's performing at those hospitals. So we really question like what is going on with like how are these vendors actually monitoring uh, their devices? And the requirement is just that they, and correct me if I'm wrong, Nate, but my understanding is the requirement is just that they have a monitoring program. It doesn't have any metrics on, how often they have to check or what is part of that monitoring plan.
No, you're right.
And
It's a special control,
yeah.
but it can be very, very general. Some companies are savvy and they'll get access to the data in their agreements, and but once again, that's expensive and it takes a lot of work. So if you can just say we'll monitor, and sometimes it's as simple as, we'll follow up on adverse events. That's part of monitoring too. And so there is not a specific way. We'll kind of go to the EU for a second. The EU has a very specific, depending on the classification of the device, post-market plan for follow-up that you lay out basically a clinical study, and there isn't that in the FDA. And so the monitoring might be as simple as if we hear about something, we'll deal with it and we'll kind of track events that occur. And if they get to a certain number, then we'll consider whether we need a device change or a labeling change or what it might take to get up to speed. But there isn't a very strong post-market
Mhm.
framework that they're going to be able to follow. And if they don't get the access to the data and they don't contract for that, or there's certain exceptions, Paul would know way better than I do about getting those data, then what are they monitoring for? The mod database, which isn't super helpful. So to Dr. Ticcanelli's point, they might be monitoring, but what exactly signals are they able to pick up? It could be very minimal.
Yeah, so ARPA-H worked with the FDA, and we don't know if we'll still have ARPA-H, but there's a program out right now called Entrust AI. It's funded at like $200 million, and they accepted proposals. We put one in, but the whole goal is developing kind of a national framework to monitor AI for software as a medical device solutions deployed across multiple hospitals. So essentially, they want to deploy 4 AI models as kind of their test cases, and then all those models would send information centrally to a platform that tracks model performance over time. And when a 5% degradation in model performance is detected, it then has a whole bunch of stuff that tries to identify why did the model fail, et cetera. But that's kind of a whole program that is being hashed out right now. And we don't know if that'll actually get funded or not now, but yeah.
Yeah, well, ARPA-H is an incredible pathway to rapid innovation, so good luck with your application. Hopefully, you'll hear good news. I'm going to let Marty Stillman, who has their hand up, take the next question for the panel.
Thank you. Brita, great job. Nice to see you again. So another area that hasn't been touched upon much, but I want to know what you're seeing with this is I do some work in the wellness space, and we're using the DAX, the Dragon Ambient experience of using AI to help with note taking for providers. So it's just a whole nother area of AI that is patient care related, but looking at some of the efficiencies that we can gain and help with wellness and reducing burnout. Have you had experience with that, either yourself or at the university?
Yeah, good to hear from you, Marty. Yeah, we are using at Alina, we're using DAX as well. And I think every major system in town is using some version of this. I know Fairview's using a different one. But yeah, I think that is, so kind of setting aside the medical device aspect of AI, I think really the vast majority of things we're using at Alina are really looking at the efficiency side of things. So when you go back to kind of the use cases I outlined in the talk, I think documentation is probably one of the most widely adopted functions. Again, I think every place in town is using something already now. I use it every day when in my clinical practice, and I love it, and you could not take it away from me. And I think similarly, when I talked about kind of chart summarization, synthesizing, surfacing data for clinicians, I mean, similar to the example Mark gave early on about the ability to sift through massive amounts of images really quickly. We do the same thing with a lot of chart summarization tools. And we have a few different innovation partnerships going on with some vendors now where we're just looking at this ability for AI to really sift through just this massive quantity of data in the health record, not only our local health record, but also connections it has to, outside health records and other, other documents as well that a human being just takes forever. I mean, think about all the chart prep we do before going into a room, or we historically have done, and we really can leverage AI to cut down that time. But again, still keeping the human clinician very much in the loop to have oversight of what's being surfaced and what's being documented, all of those things.
I agree. Thank you.
I would also say, just on top of that, making sure that you read your dictated note is always a good thing from the documented standpoint, because sometimes these tools don't always accurately translate our speech.
Yes.
Excellent. So I have one more question here from the audience that's been sent in. What role does patient input or feedback have as AI continues to be developed and adopted across all health systems? It's a great segue.
Yeah, I'll go first from a FDA medical device standpoint. FDA does have panels where patients are invited to come in and provide feedback, give input. They want to take patient feedback into account for the decisions they make. But more pointedly, if you are developing a medical device or anything AI medical product that is going to be utilized by patients, you need to run certain studies sometimes usability studies, depending on the risk of the device and how it works, where you're going to enroll part of your standard patient population and have them use the device and ensure that it can be safely and effectively used. And so if you have a over-the-counter device example, and I don't know if there's a lot of over-the-counter AI devices yet, but I imagine there will, right? That'll be considered. And so from an FDA perspective, if you want to have a broad use case and you want patients, sometimes it's just programming or something, you're going to have to consider those into your design, into your AI design, into your privacy by design, into your security by design, and make sure you are building those use case scenarios in and getting patient input from a validated study where possible.
Yeah, I think from my perspective as a litigator, I think, you always want to make sure you're getting your patient's buy-in, and to help kind of, as you're doing things, maybe just explain what you're doing as a physician, just so that they know, and it sort of demystifies everything. I think people don't trust what they don't know. And so being able to have that transparency, I think is really important.
Thank you both. I have another question here that's been sent in for Dr. Hansen. How has your organization been handling and reviewing general productivity AI tools where the tool's intended use is not for high-risk clinical use? I feel like we just went over this, actually. Maybe I could have stricken this one out. So with the productivity tools, then let's build upon this question. How does your review group that you had mentioned still review all of those against your framework, or do they still review against those framework just for the productivity tools?
Yeah, absolutely. So again, I think the same principles hold no matter which of these tools we're talking about. And so again, a lot of these, as we already touched on, the big issue is really human clinician supervision of them. So whether it be what Kelly was mentioning, that you need to review your documentation and understand that that is your documentation once it goes out there in the world, and just being sure that that education and that there's actually the proper opportunity for the clinician to oversee it. So, and then if it's more of a clinical decision support tool, where where is it that the output is being presented to the clinician, and can they make the right, have the opportunity to make the decision at the right time, for example. So I think it's the same framework. Almost all of these things continue to come up, no matter if you're talking about a more of a diagnostic tool or more of a productivity tool.
Yeah, I can expand at least on what we're doing at Fairview. When we deploy these, we look at, let's say it's one that replies to a patient message and like pre-writes an email or response to a patient, or the scribe one. We look at how often, like how many words or characters does the physician change. And then we also ask them after every time the physician uses it to give like a thumbs up or a thumbs down. So this is just some of the like the metrics that we kind of look at.
That's really helpful. I have one more from the audience here, and I love this question. I used to work in rare diseases clinical research. How is AI being used in the rare diseases space for diagnosis, research, and treatment development in the small, rarer populations?
Less than in the larger populations, like a lot less. One of the problems is that with rare events, that's tricky for AI because you don't have as much training data. So you really need data from a large amount of institutions to train those models. I'm a trauma surgeon, so in the trauma space, there's some very rare trauma diseases like aortic injury and things like that that don't happen a lot, but when they happen, it's a big deal. So there's no models for those yet, but there are initial groupings of people getting together and pulling data so that you get enough cases from a lot of hospitals. So I'd say, I don't know, it's maybe 5, 10 years behind where at least in trauma, the more common trauma diagnostic and treatment systems were being developed just because we had a lot of cases of them.
Sounds like that would be a great question to pose to the National Trauma Registry, state trauma registries, and then in the case more directed towards the question, even the rare disease consortia that exists for those particular groups.
I would say too, when you think about from an FDA perspective and industry going to FDA, you don't see a lot of AI and humanitarian devices or used in orphan drug development. And, I think Dr. Tignanelli hit it. There's not a lot of data, but also, sadly, there's not always a lot of money in rare diseases. So the investment that's required to get an AI device on market when you're not sure, A, you're going to have the data to continually improve that device, and then B, you don't exactly know what your return is, does also limit, some of the industry investment. FDA accounts for that in some of the regulations and laws around treating rare diseases and getting treatment options for rare diseases, but it still doesn't account for some of those issues from a funding standpoint. And it's just, I know it's not an easy one, but that is part of the reality too when it comes to getting those treatments on the market.
Thanks for those added points. Here's a question that is probably directed towards Kelly. From a legal discovery and business continuity perspective, how do record retention schedules fit into the use of adaptive or generative AI formats? And I was wondering about this in terms of the point that you made when you were responding to a previous question, or it might have been in your talk about not having a mirror image of the record back in time.
Yeah, I think this is going to be one of the more challenging areas. I think, what you will probably have to retain are documents surrounding the creation of the algorithm and how the algorithm was created, but the outputs will not be able to be recreated. I think that is going to be, I think, something that's going to be exceptionally challenging. I think, when we think about discovery, we think about, you don't want to have spoliation arguments or something like that, like you deliberately, didn't preserve something you should have preserved. In this case, I would argue that it's almost unpreservable, that the expanse of it is so massive and so evolving that to pick out a specific period in time to retain something is an impossibility. And obviously, I'd like to think about that a little bit more, but I think in terms of, when we would talk about retention schedules and things like that, we always were talking in historical terms of, paper documents. You're going to keep this for 7 years and then it gets thrown. I think when we're dealing with such digital and sort of evolving technology, it's going to be a real challenge to come up with something that's, you will have to maybe go to the origin source as opposed to the final output.
It sounds like we're iterating on the problems that we saw decades ago around the lack of reproducible research. Now we're not able to really prove our trail to those outcomes again with this new technology. Thank you. So Dr. Hansen, you've talked a lot well, everybody today has talked a lot about CDS as one of the biggest areas of adoption. Obviously, clinical documentation, AI has saved all of us, but particularly in the provider space. What do you all see as what could be coming next for healthcare? What is going to be the next widespread area of adoption?
Yeah, I mean, so there's a lot of buzz around the concept of, agentic AI, which is not well defined, but it's kind of what everyone wants, at least in my, again, we're really focused a lot at Align on a lot of the efficiency and productivity things. So we are so part of what we're doing is working with multiple vendors, kind of doing some development with them around very specific use cases, but we're kind of looking at a lot of these platforms that put together the building blocks that I was kind of talking about earlier. So an example would be, you have a complex uh, process within healthcare where you need to do a lot of chart summarization, but then you need to be reaching out and talking to a patient and you need to be doing documentation. So kind of how do we put all of these things together in a way, but then still allow oversight of each of these individual parts. So I think and I would also say, I think we're moving a lot away from the traditional kind of point solutions in healthcare. So, in years and decades past, working in health IT, it was actually just a big frustration is that a lot of the software that we were using were very single-threaded. They're, point solutions for one specific healthcare problem. And while that was difficult on an IT side to kind of manage all of these different things, the oversight of them was much easier because their use cases didn't stray as much. They were kind of one single thing. And now we're moving in a different direction where a lot of these AI platforms are platforms where they can be used across many different use cases, and often are put together to form kind of this idea of an agentic AI. And it's going to be much more of a challenge in terms of oversight and watching for kind of use case creep. But it's also exciting on the other hand, because we're looking at kind of single platforms that will be much more efficient to use across many different use cases.
I agree completely with everything that Brita just said. The other piece that I think we're going to really start seeing in about next 10 years is robotics. Robotics is really coming along at a fast speed, and it's kind of like AI. Like GPT came out in 2018, but no one really heard about it till 2022. So it's so behind the scenes, we're seeing a lot of movement in the robotic space, and I think it'll really get to a pretty impressive state in the next 5 years. To give an example, 2 years ago, no, that's 3 years ago now, Johns Hopkins, they did 3 autonomous surgeries in pigs. So the robot went in autonomously, found a piece of bowel that they inked. They put some ink on it and said, resect this piece. And that's what we do in real life too. Found the inked piece of bowel, stapled it out, put the intestine back together and got out. And that was 3 years ago. So I think we're going to start seeing really interesting uses of robotic AI in healthcare. And I think it's not just going to be like in the clinical space, like can you remove this piece of intestine, for example, or do surgery, but also in like the efficiency space. So there's a robot system called Gary that's out right now that's being used in some hospitals, and Gary will deliver food trays to all the patients in the hospital. Gary will clean the rooms, has like a built-in UV thing that they use, and this interesting arm that drapes over the bed and it mops and all that, or stocking the operating room before surgery the night before, because we stock it for every surgery the night before. So a lot of those things, I think you're going to start seeing more and more robots.
That's very exciting. And my last question was going to be, what are, the biggest opportunities we have? So thanks for kicking us off with that. And I want to just open the floor to the panelists for any last final thoughts as we close up here.
Yeah, I would say you need a strong FDA, a well-informed FDA, and an FDA with, well-resourced to be able to review all these advancements and innovations coming because, most of the things discussed today were at a level that you would have FDA review, approval, clearance, whatever it might be. And, making sure you can get through FDA timely ensures that the treatments that are developed are delivered timely because the innovation is so expansive and fast. And so, making sure if you've got these ideas, you've got these technologies, partner with FDA as soon as you can and, make sure that you're giving them what they need because ultimately they're that final gate to get into the marketplace and serve patients.
I would say if I had to give a final thought, it's just to appreciate the sort of the how quickly AI is developing and how many advancements can happen in such a short period of time, and how our law really lags behind that. And it's, our laws, our case law, and the education and kind of socialization of these issues with our colleagues in the legal department or in the legal profession and with the public at large, because ultimately, if cases go to trial or things like that, it's the public that is going to make a lot of the decisions in terms of verdicts and the like. So I think that's just something to keep in mind, is that we're moving at a super rapid pace, and we want to make sure that we're bringing everyone along because we're all going to be in this together.
Yeah, and I'd add to that. I mean, I think we're in a very exciting time and there's a lot of things that can be done, but I also think, we have to just go back to the basics a lot of time and, be reassured that we do know how to kind of have oversight and look into these things and not be so scared that these are systems that are going to run away with things. But we have to really, adhere to the discipline of our best practices and evaluation and a multidisciplinary team to stay on top of these things.
I think that was well summarized. I don't have a lot more to add. I would embrace it, but there's definitely need for more regulation. There's gonna be a lot more in that space going forward.
Great. Thank you all so much for wrapping us up. And thank you to all the speakers who've been here today. Professor Colombo, were you going to close us out? Here we go.
Thank you so much, Molly, for doing a great job. And this was just an outstanding group of speakers. I think we all learned a lot. And the biggest indicator is we had most of the folks that participated, that registered, stuck with us the whole time. So that is a testament to having a very engaging group of speakers. So thank you all so much. Thank you everyone for joining us today. And we'll see you with our next event. Have a great day, everyone.
Thank you.